Yes.
Okay, they're ready.
I don't know where Mr. Abbott is yet.
Austin is Antoine Martin present?
Yes, he's in the courtroom, Your Honor.
Okay, where's our, prosecutor?
That's the whole witness. That's what you're-
Okay, on the record, in the matter of the people of the state of Michigan versus Antoine Durrell Martin, phone number 23-01830. Council Pence, please.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Jared Austin, appearing on behalf of Mr. Martin, standing present to my right, counsel. Thank you.
Today's the date set for a preliminary examination. Are we expecting this to run today?
At this time, Your Honor, I have not, I attempted to call the complaining witness last night. I did not make contact with the complaining witness, and I don't believe, and I was just going to check this here, but I don't believe our office has had any contact with the complaining witness. So at this time, it does not look like it would run, Your Honor.
Council, how do you want to proceed?
Thank you, Your Honor. Your Honor, given that the complaining witnesses have not had contact and is not currently present, I would be moving the court for dismissal at this time. She did not appear, understanding, of course, that the dismissal would be without prejudice.
Grant your motion to dismiss without prejudice. That means that the people do have the right to reissue the charge against you. Do you understand that?
Yes, ma'am.
Do you have any questions about that?
I have a tether. What does that do for that?
When this case is going to be dismissed, you're going to get a copy of the nollie in just a moment. Then you can go back to Mason and get that removed, okay? Any other questions? Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing additional on behalf of Mr. Martin, Your Honor. Thank you.
Thank you.
I would just need to see if I'm not aware that my victim has shown up. I would just need to call the hallway one more time. Make sure they're not here. Yes, we're ready. Here.
On the record, in the matter of the people of the state of Michigan versus James Williams II, file number is 20-020 59 FY council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of James Williams.
How are you, Mr. Williams? I'm doing all right. Today is the date and the time that was set for a preliminary examination. I think last week there were some discovery issues. I'm assuming that was resolved. However, Mr. Brodowitz, did you find your witnesses or have you been in contact with them?
No, Your Honor, at this time, the people have subpoenaed witnesses. I have not had any contact with the complaining victim in this matter. And I called the hallway in the courtroom. She has not appeared today, so she will be unable to proceed.
Honor, the defense moves to dismiss this matter today. We are aware that it is without prejudice unless we have to dismiss the matter.
Motion to dismiss is granted. You'll get a copy of the dismissal shortly. As your attorney has indicated that dismissal is without prejudice, so that means that people do have the right to reissue the charge against you. Do you have any questions at this time for the court?
No, ma'am.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing on behalf of the defense other than Mr. Williams, if there are other no contact orders between you and Miss Morris and Trevino, those other orders are still in effect. Yeah.
As it relates to this file, or is there another file?
There's a couple other files around.
Okay, sounds good. You're all set. Thank you. A lot of people in custody. Yeah, it's just right here. Mr. Hayward is here.
Yes.
We're just waiting for his attorney.
I have a question for you.
Yes.
I got a client, Ralph Thompson. I think in a few minutes, the matter is gonna probably end up being a dismissal. No witnesses have appeared yet. Client's in custody. You want him brought up?
I don't even know if Ingham County Jail's pulled in yet.
Yeah,
I don't think they have either. I doubt it. They never heard 8:30.
That's up to you if you want to waive your client's appearance. Yeah, that's up to you. I don't
You
know.
don't come in there. I guess I'll see how.
We have a whole lot of people in custody today, so if you want to waive, that's fine with me.
I'll make sure he knows when he gets here,
Okay, that's good.
or before I leave this morning.
Do they notify you when the jail pulls in?
What's that?
Do they notify you? Good morning, how are you? Okay. On the record, in the matter of the people of the state of Michigan versus Patrick Hayward, file number is 23-01973. Council appearance.
Good morning, Your Honor. John Am, representing Mr. Hayward. You stand to my right.
Okay, Mr. Hayward, today was the date set for a sentencing and a PA 53 violation. Let's see. You were previously arraigned on the PA 53 violation, looks like by Judge Greenwald. And I think we reset the PA 53 hearing for the time of sentencing. What's going on with our screen?
You got any?
I don't know what's going on. Something's messed up. Okay, let's see. I believe the PA 53 violation was relative to a traffic stop on a moped. Do you have another matter pending from that?
From what has resulted in the bond violation, Your Honor?
Correct.
Not at this moment. I checked on the status of that earlier this week. It was temporarily refused by the prosecutor's office in order for the PD to do further investigation into that matter.
Okay, Mr. Hayward nodded his head yes, so for some reason he believed.
Yeah, I think I have something pending from not mistaken, the court on the 15th. Next one.
Or the slants?
Two more feet.
You say you have a court on the 15th.
Next one, I believe.
It's a pre-trial.
I guess.
What's the charge?
RNC.
About motor vehicle, another moped. Allegedly.
Okay, well, we'll let Mr. Brodowitz look that up while we address the sentencing. I have a pre-sentence report and recommendation here. Did you get a copy of that, Mr. Abbott?
Yes, Your Honor. In just a second, my computer just finally connected to me. We have received it and we reviewed it prior to the first scheduled sentencing.
Okay, any reason to make updates, corrections, or deletions?
No, Your Honor.
Okay. Let's see. My first concern, I say, would be that sorry, have undergone a substance abuse assessment prior to sentencing, Mr. Abbott. So why was that not done?
I've been intending to make an appointment for the last 2 weeks now. And I can't seem to get in anywhere. I mean,
Last 2 weeks, you were supposed to do that back
I know I was
in July.
I know I was in jail, and then I got out, and then I was working out of town for a whole week. And then I was on, 6 o'clock in the morning to 8 o'clock at night. Plus drive time. And so like as soon as I got back from work, I started trying to make an appointment. I couldn't get in anywhere, and I made one appointment, and then I was on my way there on the bus, and my bag popped on me, so I had to get off the bus and go back home. It was just a big fiasco. I apologize.
Okay, so Well, my concern is if you couldn't do that in the last 2 months, what about your life is gonna change when you have more requirements under probation?
Well, negotiations for like, I don't know, I
That, that sounds like gibberish.
apologize. There's no excuse for me not to have that, I apologize.
Mr. Abbott,
Thank you, Your Honor. He's told me he's never gonna buy another, or acquire another moped from questionable sources again. So at least that part of his behavior is changing so much, insofar as part of his behavior may or may not be part of the substance abuse problem. I'd ask the court to give him a chance again to connect with probation and connect with the assessment. Unless he does have a case in.
Mr. Roderick, you able to confirm?
As far as my system tells, Your Honor, that case is, as I said, still in screening. Last note that I have in the system is that it was temporarily refused for the police department to do more investigation on that, Your Honor.
Well, you said the 15th of what month is your court date?
October.
In 54B?
Yes.
Okay. I couldn't say one way or the other, but I'm going to dismiss the PA 53 because the allegations are being screened for further prosecution. That relates to the pre-sentence report and the recommendation. Probation indicates you were ordered, as I've already stated, to undergo a substance abuse assessment and submit the results to probation by August 25th. This report that I'm reading was dated for September 1st, and you never provided an assessment. And so when is your appointment to have an assessment?
It's Tuesday, Tuesday next week.
Where?
Kristen, right? Yeah, I made one there previously, and then like I said, I was on my way there on the bus, and my bag popped on me, and I got to look at that home.
Other than that, it states that you scored high in the responsivity domain, moderately high in companions, leisure and activities and personality characteristics, and moderately low in attitudes, behavioral, and substance use domains. It's clear that you would benefit from a term of probation, as well as some treatment for substance abuse, but we can't really identify how to do that until you do what you're supposed to do, which is a substance abuse assessment. Also, the recommendation indicates that you may need some counseling for mental health as well. Are you already attending mental health counseling?
No, man, it's so like I have a hard time doing paperwork, and like so I need help doing it. So I have a friend that's helping me. I'm gonna go ahead and sometimes a week. I started again. And I've previously attended it in the past, and I need to there you go.
Okay, so you need to re-engage in your
Yes.
counseling.
Yes, ma'am.
So with that being stated, I'm going to order that you get a substance abuse assessment completed and a report tendered to our probation department within the next 30 days. I am going to place you on a term of 9 months probation. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess firearms, ammunition, or weapons of any kind. You understand that?
Yes, ma'am.
You're not to use or possess alcohol, marijuana, or a controlled substance unless you have a valid prescription. Do you understand that?
Yes, ma'am.
You will be required to submit to random preliminary breath testing and or your analysis testing and pay the fees associated with that, okay?
Yes, ma'am.
You're not to be in any bars or any nightclubs while on probation.
Okay, can I ask a question about that? I'm about like I'm a bouncer by, was one of the things I do. Would I still be able to bounce being on probation? You sometimes, there's a company called Zero Tolerance here in Lansing. I sometimes midnight for them.
You said you
You
do security
Yeah,
for
right.
where?
Zero Tolerance,
Where is that?
out of Lansing, there's a company based in.
It's a bar?
No, so it's security company.
Okay, but they send you to bars?
Well, yeah, some bars, concerts, it all depends.
You shouldn't be at any bars.
Okay, fine.
But if you're gonna be there for work purposes only, you need to provide verification to your probation
Thank you very much.
officer, okay?
Thank you very much. Just wanted to be clear on that. I wasn't trying to get in trouble.
You provide verification before you go,
Absolutely.
not after you get
Yes,
violated,
absolutely.
okay?
Yes, sir.
Thank you. Okay, so I noted that here on my order. In addition to that, you are again going to complete some outpatient substance abuse, and we'll find out what that looks like once we get an assessment. You're going to re-engage in your mental health counseling, and you'll be getting mental health counseling regularly. You'll be required to provide proof that you are completing counseling, okay?
Yes, sir.
Do you have any questions so far?
Well, no, you're right.
You're required to maintain your employment while you're on probation. You also attend any other programming or treatment as recommended by your probation officer, okay?
Yes, sir. I applied for more. I just had 2 interviews this week for jobs. So
Very good,
I'm trying.
very good. Okay, as part of probation oversight, there's a $30 fee that will be assessed. There's a $75 crime victim rights fee that will be assessed. That's a $50 state minimum cost. I have here restitution is owed to victim Gerald Trumbull in the amount of $490.14. That's correct.
Yes, right.
I'll waive discretionary fines and costs. In total, fines and costs and restitution will amount to $885.14, and you'll be making monthly payments on that, okay?
Thank you.
So it's about 98 and some change per month. Mr. Bigelow, can you provide him that? That's an advice and rights as it relates to probation, early discharge, and when you would be eligible, if eligible, to request early discharge from probation.
Yeah.
Okay, do you have any questions about those rights?
No,
So, again, you would have the right to request early discharge from probation after you've completed half the original term ordered without any violations within the 90 days preceding that request. You would need to make a request by using our MC 512 form, which is the early discharge form that's on the court website, or you can get that form from our probation department. You would make that request, you'll give a copy to the probation department. You'll also provide a copy to the prosecuting attorney's office. They have 14 days from receipt of that to respond to your request. If a hearing is set to address your request, you would have the right to have an attorney represent you, but you would have to hire that attorney. You do not have the right to have Mr. Abbott or court-appointed counsel represent you for that hearing, okay? Then lastly, that request can also be made by the probation department without you having to prompt, okay? So unless you were on probation for domestic violence, criminal sex crime, stalking, or an offense where guilty but mentally ill was asserted, you would be eligible to make a request for early discharge after completing half the term without any violations, okay? Mr. Abbott, did you have something? Oh, okay. Do you have any questions about what you're gonna do from here on out? Okay. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Not from the defense, thank you.
Thank you, you're all set. Mr. Feigelson, did you want us to call your case?
I could, yes, please, Your Honor.
On the record in the matter of the people of the state of Michigan versus Ralph Thompson, file number is 23-01852. Counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Ralph Thompson, Your Honor. He is here. I think he's downstairs in holding his hat.
Okay, did you want us to bring him up or did you want to waive his appearance for this
I
purpose?
can move his appearance.
Okay, today was the date and the time that was set for a preliminary examination. Mr. Brodowitz, have you had communication with your witness?
Your Honor, our office prior, I can't remember the exact date, but prior to this did have contact with the complaining witness. However, I have not had any contact with the complaining witness, and a representative from our victim witness unit has not heard from, I just spoke with her and she has not heard from her either. And as far as I know, she has not appeared today, so though she has been subpoenaed, so with that, the people would be unable to proceed at this time.
It says that this case be dismissed wherever it is without prejudice, nonetheless, we'd ask for it.
It's being held on something else.
I think he's got a hold out of Clinton County, Your Honor.
A motion to dismiss without prejudice is granted. And you can advise him of what that means.
I will, Your Honor.
Any additional matters for this record?
None today, Your Honor.
Nothing from the people, Your Honor.
Thank you, you're all set. Thank you.
Yeah, we didn't have the report side.
Jamie Nelson for the people.
Good morning, Judge. How
How
are
are
you?
you?
I'm good. How are you?
I'm doing well, I love you here.
Thank you. I love yours. Yours is always great.
Thank
So much
you.
more fun than mine.
I'm gonna go with him.
Do you have a quick experiment?
Mr. Mills,
Hello, Your Honor.
how are you?
I'm good. How's my hair?
Same as always.
Well, thank you.
Tommy.
Okay, we're ready on.
We are ready. I'm Mr. Bozeman. I believe, Your Honor, it's going to be an adjournment request.
Okay, we're on the record. In the matter of the people of the state of Michigan versus Tommy Lee Bozeman, file number is 23-02387. Council appearance.
Good morning, Your Honor. Jamie Nelson appearing on behalf of the people.
Good morning, Your Honor. Stephen Milton, behalf of Mr. Bozeman, who is present and staying to my right at this time.
How are you, Mr. Bozeman?
All right.
Your hair is nice too, by the way.
Yours too.
Okay. So, today's the date and the time that's set for a preliminary examination, and there's a request to adjourn. Is that correct?
That is correct, Your Honor. It's my understanding that Mr. Bozeman would like to retain counsel. The people had always intended to need to request this hearing to be held in part due to an officer who is unavailable for today. We do have a number of officers present in the courthouse, so we would be able to begin at the moment. However, considering the fact that we'd already intended to come back for a second day, the people would not be prejudiced in any way by allowing Mr. Bozeman the time to retain counsel. So we have no objection to it at this time, so long as the court schedule can accommodate that.
So you needed to do this in 2 days anyways, correct?
Correct.
And then, Mr. Bozeman, you would like to hire your own counsel, correct?
Yes.
Okay. Have you already made contact with who you want to engage, or do you need time to do that? I'm sorry? You need some time? Okay. Okay, so you have the right to have a preliminary examination within 21 days of your arraignment. I think it looks like I've already addressed the timeline at the last court date because of the pending discovery issues. So we'll go ahead and adjourn this so that we can do this once you get an attorney, but we probably want to make sure you get an attorney first. So why don't I set this out for a status update first? We can find out who your attorney is and make sure they get discovery. And then we'll set the exam dates for the 2-day exam, okay? Let me have a status date, next available date, I guess.
She left October 5th at 8:30 for a PCC.
October 5th at 8:30. Does that work for, do we know if that would work for Ms. Houseville?
I do, Your Honor, and it does.
Okay, sounds good. Okay, so you'll return on October 5th and hopefully with an attorney that you've hired, okay? Do you have any questions at this time? Any additional matters for the record?
No, Your Honor, thank you.
No, thank you, Your Honor.
Thank you, you're all set. We'll
Thank
get
you.
you a notice to appear in just a moment.
Your Honor, it's always good to see you.
Same to you, have a good
great
one.
day.
Thank you. What's going on with our poly files?
Your admission.
Of course he does. Can't stay away.
I know. I just thought you'd find that.
Always, I appreciate that.
Thank you.
And you got that. Yeah.
Okay. Your,
20 year mark.
The jail thing?
It should be by now, man.
The majority of my docket is in custody, so.
Yeah, but it should be by now.
Your Honor, may we approach?
Well, I mean, you're pretty much here.
I'm backing up. I'm
Did you want to approach again?
Good, thank you. You have the nation blessing holiday season.
Same to you. No, I think I need to. What's your name, sir? Oh, he probably doesn't have audio.
He retained. Yep. Okay, that's even, she's retained and explained. So good enough for me.
Thank you.
And I can sign as long as I know what's going to the judge and I get a copy of it, Boston, I can do it. So, thanks, Judge.
No problem. I didn't really do anything, but no problem. I'm sorry?
I thought it was Boston slash.
Yeah, that's because it was, and then she retained counsel. Mr. Palmer's here. He's on Flores, correct?
Yes, ma'am.
But we need, who's it, Gallagher on that one?
No, that would be Ms. Castleman. She is here.
I just asked her if we're ready to go on that. She said that they're still waiting on the officer to be here. It sounds like the officer's going to be here, she thought. She's just not quite here yet. That was the
Okay.
impression I got.
Who was the other lateral? you told me?
Ms. Gallagher.
No, which that was that?
Oh, Birmingham.
Birmingham, okay.
I can give her a call really quick, Your Honor, and see if I can find out where she is, if she's not here yet.
Birmingham, I'm right here.
No, we're looking for
No.
the prosecutor. for that one.
Okay. I'm sorry.
No worries, we knew you were here.
At least the appearance. Oh, and the substitution.
I just signed it.
No problem. I just have to enter it and then I can pick up.
Thank you so much.
What's your name, sir?
Jason Murray.
Jason Murray. He's on custody too then. Okay. Is that Aaron Robinson's case? Okay, Mr. Murray, we need to find your attorney. We're gonna put you on mute until we find her, okay?
Thank you.
No problem. Mr. Abbott, are we running Smith?
Willie Smith, yes, Your Honor. Last time I spoke with him, I'm gonna go down and talk to him again to make sure.
I was just told you were already talking to him. That's where they told me that's where you just were right,
Trying to get there, Your Honor.
right now. Well,
Well, you can bring him up and I'll ask him.
I was gonna say, we might as well bring him up now. Willie Smith,
He's consistent.
sounds good.
Your Honor.
Yes, sir.
Ms. Gallagher was parking. She said she'd be here in 3 minutes. The victim is here, so she'd be ready to proceed when she gets here.
Okay, we're running Mr. Smith, I believe, so we're going to get him up because I think. Well, that was set for 8:30,
Yes.
but then there's several at 9 that are gonna run too, so we gotta get this show on the road. Your name, sir?
Yes, I.
In the jail? What's your name?
My name is Gautama Haptalam.
Mr. Nickel. Ms. Robinson, your client is here. Did you need to speak to him at all?
I don't believe so. I believe we're ready.
Okay. Okay. I'm gonna call Mr. Murray. On the record in the matter of the people of the state of Michigan versus Jason Ray Murray, file number 23-01950. Council appearance.
Jeff Radowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Murray.
Okay, Mr. Murray, today is the date set for a plea. Do we have a plea sheet on this?
Not yet, Your Honor.
I have an email. Is it the offer for him to plead to count 2 and dismiss count 1? Is that the offer?
That's correct, and also dismissing the second offense.
Yes.
Second offense notice as well, okay. And so, Mr. Murray, can you unmute your device?
Can you hear me?
I can hear you now. Did you hear the offer? The offer is for you to plead guilty to count 2, and the people will in exchange dismiss count 1 as well as the second offense notice. Is that your understanding of the offer?
Yes, ma'am.
Do you want to accept that offer today?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Ma'am.
Okay, you can put your hand down. Okay, Mr. Murray, You were charged in count 1 with assault with a dangerous weapon, that's felonious assault, and then count 2 as domestic violence. So the charges here, you have the right to proceed to a trial, and you have the right to a jury trial. Do you understand that? Sorry?
Yeah.
Something's going on with your audio, so it's not picking up.
Yes, ma'am. I'm picking up now.
Okay. Yes. Okay, so you want to waive your jury trial? You want to give up the right to jury trial, sir?
Sure.
Excuse me? Okay. You have the right to have the prosecution prove your guilt at that trial by proving each element beyond a reasonable doubt. And you have the right to confront in court any of the witnesses that the prosecution intends to call, and you have the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you. Do you understand that?
Yes, ma'am.
And you have the right to remain silent at your trial and not have silence be used against you. Do you understand those rights?
Yeah.
Excuse me?
Yes, ma'am.
Okay. Are you willing to give up each of those rights today?
Yes, ma'am.
Anybody making any promises to you to get you to give up your rights? I hear nothing. I'm gonna reset this. He needs to appear in person.
Understood, Judge. Mr. Murray, you'll have to come back in person to a new court date because your Zoom isn't functioning. The audio on your Zoom isn't functioning, okay?
Okay. When was this gonna be?
Give me just a moment.
Yeah.
It's October 29th at 8:30. What do you need to go figure out?
No, actually, they're gonna modify my September 29th docket because I need to go back to Boston. So, he could do it on a misdemeanor docket too.
Okay. All right.
You can go the week after, that's fine. What is it?
October 8:30.
October 8th. Yeah. Okay, we'll do October 8th at 8:30. Does that work for you, Ms. Robinson?
It does work. Thank you, Judge.
Okay. Do you have any questions today, sir?
Yeah.
Okay, you're all set.
Over 8.
October 8th at 8:30.
Okay. Okay. 8:30.
I'm sorry?
October 5th.
Oh, October 5th. It's October 5th, not October 8th.
Okay.
Okay, thank you. Oh, you're fine. What do you want me to do with this? What's this here?
This is Willie Smith, Your Honor.
They want to wait.
Wants to wait. Okay, on the record, in the matter of the people of the state of Michigan versus Willie Smith, file number 23-02645. I also have 23-02437. Council appearance.
Yeah, Bradwitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Mr. Smith. He's standing to my right. Brennan, did you call 2 cases?
I have another case, so one was set for a PA 53.
That's
That's the one that is set for exam on the 20, I mean, on the 5th. Okay, Mr. Abbott, you're on this file as well, though, correct?
Right, and just to make sure I'm right here, 23-2437 is set for preliminary exam next week.
It's set for preliminary exam next week, correct? And it was set for a PA 53 today.
So that's what
Yeah, I'm not sure why that happened, but nonetheless,
I-
we'll address the file ended in 2645 first. This matter was scheduled to have an exam today, and he wants to enter an unconditional waiver. Is that correct?
That's correct.
For the people waiving their right to exam?
Yes, people would also agree to waive their right to exam with negotiations to continue in circuit.
Okay, and so Mr. Smith, you do understand that you have the right to have a preliminary examination on this file in the district court? You understand the purpose of the examination is to require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
You want to unconditionally waive your right to examination?
Yes, ma'am.
Anybody threatening you to get you to waive your exam?
No, ma'am.
Because you're gonna need promises made to induce you to waive your exam.
No, ma'am.
Waiving it freely and voluntarily.
Yes, ma'am.
Let's see here. Your waiver was made freely and voluntarily. Your bind over date will be September 27th. You do not need to appear in circuit court on September 27th, so that's the date they're gonna get the file from this court, okay?
Yes, ma'am.
Your next court date will be in the circuit court, but it'll be a trial, your attorney will be made aware of that date, okay?
Yes, ma'am.
Bond in this matter was set at $50,000 cash surety. That will continue. Any additional matters for this file?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Okay, you're all set on that one. And then I don't really know why we set this for APA 53 today, unless he just needs to be arraigned. Let's see. No, he was arraigned on this. Set the same date as the actual exam. So we'll reset that. So that'll be set to October 5th at 10:30 minutes. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense on that, Your Honor.
Thank you.
Inquire, Mr. Hampton, which is a, is there a plea sheet? I realize this comes from last year. Is there a plea sheet done?
Do you know who Mr. Nickel is?
Yeah, I'm not sure if he's here yet.
Who?
Mr. Nickel?
Mr. Nichols is starting trial today, Judge. I don't think he's gonna be here.
Oh, well, his client is here. Is it with Aquilina?
Yes, ma'am. He's with Judge Shockman and Adam.
Okay, so then this needs to be reset. Absolutely. You wanted to know if there was a plea sheet in here? Mr. Abdullah, your attorney is tied up on a trial, so we're gonna reset your matter, okay?
I can represent myself.
That is not okay, because you already have an attorney, and so if you want to do a motion to have him removed as your attorney, we can do that. But it won't be right now, so that you can get your case moved on. We're not doing that. I don't see a plea sheet in here.
Okay, I just wanted to know if one was one was needed, in which case I'll have to figure out with Mr. Nichol what exactly we offer, because our notes are a little sparse on that, Your Honor.
You said that again, I was reading something.
No, October 6th, 9:30.
October 6th at 9:30. Okay, you're all set, Mr. Hamilton.
Who would you like to see first?
I'm sorry, I couldn't hear you.
Actually, one sec. You may be able to move the rest of the 9 o'clock. before the-
I saw Miss Gallagher.
Yeah,
I saw
that's.
Miss Castleman.
Let me see if I have my witnesses here on Robinson.
I was gonna say
Turner,
Robinson.
Your Honor, and those we may be able to take care of.
Sounds good.
Just take care of pieces.
We're kind of running up the flagpole.
Why not? But we can do that later. We can break into something that we can get in sex. I think she's.
Yeah. I'll be with you.
Remember what we gotta get in sex.
For a special.
Let's we can just do that. Then we move forward once we-
Okay.
then we don't-
Which matter?
Sorry, Mr. Marcos, who's here?
Mr. Marcos is in custody, isn't he?
He
No?
just.
He's not in custody. On the record in the matter of the people of the state of Michigan versus Jeremiah Marcos, file number 23-02623, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Marcos, who is present and staying to my right at this time.
Today was the date that was set for preliminary examination. Let's see, how are we proceeding at this time?
Believe this, and I think, well, I'll leave it to Mr. Milks to clarify, but I believe this was set for a PCC at his request, Your Honor, for this week.
And Your Honor, that is correct statement, Your Honor. Today is the date and time for the PCC. As we indicated in this court, we thought we could come to a resolution in this matter. I do believe that's still possible, and we are looking for a specialty court plea offer in this matter. The original offer was to see about getting my client into drug court. We were asking for potential mental health court. Either way, we definitely want to get him assessed. We just need to make sure that that agreement's okay regarding mental health court. So at this time, Your Honor, we'd like to just leave it on. I believe it's scheduled already for September 28th at 9 o'clock for preliminary exam. I anticipate us not asking for or to call in witnesses that day. But right now we do know we just want to get him assessed at this point. Figured we'll just get that started.
Sounds good. I do see a note here that this was, I had found good cause to go beyond the 21 days. And then this was set for PCC today. Okay, so we're going to continue to that September 28th date, and then he's going to, or you're going to see if he can be screened for mental health court.
That's correct, Your Honor.
So we'll continue to that date. Any issues we need to address on the record today?
Nothing from the people, Your Honor.
Not from the defense. Thank you, Your Honor.
He's on GPS tether, correct?
He has to get that set up. I don't want to go take him to probation today to see what we can do. He has to show proof of indigency in order to get the GPS tether put on. So we're going to be doing that today.
He wasn't supposed to be released without GPS tether.
And they told me he had to go figure that out.
They told, who told him that?
Jail.
The jail released you and told you had to go figure out GPS tether?
Yeah, I had to send them information stating that I had a food stamps or Medicaid, and that would be covered to where I don't have to pay for it. And all I had to do was show one of those two cards, email them with that, and then I'd be good. That's what we're gonna try and do today.
Yes, that's what we're going to try and do today.
'Cause I only had 5 days to complete it, power release from jail.
I didn't say he could be released from jail without GPS tether. I'm confused.
I have tether on.
You do have
You do have
GPS
tether.
I
tether.
do have a tether on.
That was good. That was my question.
Okay, I'm
I
sorry.
just
was
have to show
confused.
proof, so I don't have to pay.
I
for
want
the
to know, what
tether.
is this new policy? We're releasing people and then they can come back and get the tether. That's dangerous.
Yeah, I apologize.
Okay.
I misunderstood. That was my
Okay.
fault. I apologize.
Thank you.
Okay.
I thought maybe I missed something. Okay,
No.
sounds good. All right, so a bond will continue. Any additional matters for today?
Nothing from the people, Your Honor.
Not from the defense. Thank you.
Thank you.
Thank you. Okay.
Just 1 second, Your Honor.
Good morning, Mr. Samuels. Well, he doesn't have audio.
And just to give you an update, Your Honor, I believe, I'm not sure where Ms. Gallagher disappeared to, I can find her, but I know Ms. Castle is ready to go on both of hers.
Okay, sounds good. Mr. Samuels?
Yes, Your Honor.
Which matter are you here for?
I'm covering for Jeffrey Rothstein today. And Jeffrey Rothstein is on Robinson.
Okay, she's retained counsel and her counsel is here, so you're all set.
Awesome. Thank you.
You're welcome. What about the matter for Birmingham?
When that I need to find where Ms. Gallagher went, but we are, I believe, both Ms. Robinson and Mr. Turner.
Your Honor, Ms. Gallagher said she was gonna go talk to the complaining witness.
Okay,
But I know.
Ms. Gallagher's ready to run first,
Oh.
and we can run. So we have 3 that are ready to run,
Yep.
Your Honor. That should be relatively quick, each of them.
On the record in the matter, the people of the state of Michigan versus Tashari Robinson, file number 22-03212 FY, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Melissa Patton on behalf of Tashari Robinson, who is here to my right.
Okay. Here's the necessary witnesses have failed to appear. The people are moving to dismiss without prejudice.
No objection.
Okay, sounds good. Do you have any questions about that, ma'am?
No.
Okay, so we'll get you a copy of your motion, your dismissal, then you'll be all set. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Okay, you need to wait at least 72 hours for us to remove the no contact order that's in the system, okay?
Okay, thank you.
Thank you. Ms. Donnelly, did you want us to bring your client up or are you just gonna advise them off the record?
I will advise him off the record, Your Honor.
Here.
Your Honor, no, I didn't think, that's Feigelson. I don't know if he's here anymore, but I told him I'd cover it, but he didn't expect her to be here. He doesn't have good contact information, so she's
Okay,
not here.
sounds good.
I'll go check the outside dog. I'll call it.
I'm sorry? Big warrant for her. They want, Mr. Abbott wants a adjournment for Linton. Shout out to it. I don't see.
She was representing.
You can go and get,
Tina Moon.
I just asked for a big one, she's not here. I mean,
She-
it's your
I
big
checked
one.
in all the hallways. She's not
Mr.
here.
Brodowitz, you can go, I don't know who's running first. Is it Gallagher?
We'll do. Oh, okay, we don't need to go on the record for Turner then?
No, she just, I don't know, I
Okay.
want to go downstairs and talk to her.
For who? Oh, Turner, we're not going on the record. She's gonna advise me.
I will go whichever one you want, either Ms. Gallagher, I think that would probably be the best way to proceed. So I will-
Sounds good. He's still, Linton, they're still looking for him. Is that what's going on? Going on with Linton?
I got an email yesterday that he was released from Eaton County to Tri-County.
So we need to rid him from TRICAT? What, I don't know what the plan is. Is Mr. Abbott gone?
Oh, yeah.
Can you grab him? Mr. Bickles, can you get Mr. Abbott, please?
I can grab him.
Oh, thank you.
Oh.
I'm sorry.
He's right up.
Okay,
He's right
thank
here.
you.
Hey, Judge. Miss Moon was here. She was talking to me.
Mr. Abbott, how do you want to handle Mr. Linton? He's in TRICAT now, is my understanding.
Right, I don't know if I'll be able to zoom in today or not.
I don't think so. Do you want us to just reset it?
Yes, please.
Okay.
What she was talking about.
Okay.
I'm glad you made it.
Okay.
I'm sorry. Oh, I'm sorry.
Birmingham?
I was told Matthew Birmingham. If that's not correct, I can.
That's my understanding. Are you running move?
We're gonna enter into the plea today, Your Honor.
Yeah, that's not Plea. I'm filling out plea sheet now, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Matthew Birmingham, file number 23-02230 FY, council appearance.
Thank you, Your Honor. Good morning. Ailish Gallagher on behalf of the people.
Your Honor, for please this honorable court, Mark Satawa, appearing on behalf and along with my client, Matthew Birmingham, in this matter.
Today is the date set for a preliminary examination. My understanding is that we are ready to proceed, correct?
Correct, Your Honor.
Yes, that is correct, Your Honor.
In preliminary matters.
None from the people, Your Honor.
Nothing for the defense, Your Honor. Thank you. I would ask for a sequestration order on witnesses.
How many witnesses do you have?
I only have one, Your Honor, the victim. The victim did have a friend that came with her to court today. I did inquire because I thought the court would want to know if she was a witness to anything. She said she had no personal knowledge to see anything. And I told her that there would probably be a sequestration, but I would inform the court where I had inquired.
Sequestration order is granted.
Thank you, Judge.
You can be seated. You can call your witness.
Thank you, Your Honor. The people called Tabitha Birmingham.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat. So there's a microphone that's in front of you, and right behind you is the court reporter. She needs to take down everything being stated in the courtroom today. So all of your responses, they need to be verbal, loud and clear and audible so that we can understand them, okay?
Yeah.
Okay, and then also if there's an objection from either attorney, you would stop speaking immediately. I'll make a ruling on the objection and then I'll tell you if you can give that response or not, okay?
Yeah.
Also, you can't do head nods and shakes or mm-hs and uh-huhs, because we can't explain that in the record accurately, so we need you to answer yes or no questions with yes or no. Do you have any questions at this time, ma'am?
No.
Okay, state your first and last name for me and spell both of them.
Tabitha Birmingham, Tabbabhatha Birmingha.
Okay, you can proceed, counsel.
Thank you, Your Honor. Tabitha, do you know Matthew Birmingham?
Yeah.
How do you know him?
Ex-husband, together 17 years.
And when you say ex-husband, did you formally divorce?
Yeah.
Okay, and when was that?
January 2024.
And do you see Matthew Birmingham in the courtroom today?
Yes.
Okay, could you just point to him and identify an article of clothing for the record?
Will we try?
Let the record reflect that identification is met for preliminary purposes.
The objection to identification. Identification is noted.
Thank you, Your Honor.
Can I just ask one question, Your Honor? I'm sorry. I haven't been in front of Your Honor before, and it's kind of like a cramped situation. Does Your Honor wish us to remain seated when we address the court, or do you want us to stand?
You're fine.
Okay. I didn't
Unless you're.
I didn't want to put the objection on the record while seating. I didn't want
Yeah,
to think
yeah.
I was being
It's
disrespectful.
customary to raise when you're speaking, but I recognize this is a small court.
Yeah, so I do apologize, Your Honor.
You can continue.
Thank you, Your Honor. Tabitha, do you remember April 21st of 2023?
Oh, yes.
Okay, and was that a day that the defendant was supposed to move out of the house?
Yeah.
Prior to that date, do you remember something physical happening?
It was, yes.
And how close in time to that?
It was after midnight, so I guess it was at April 21st. But
Okay, and so at this time, were you residing at 6947 Carlson Drive, City of Lansing, Ingham County, Michigan?
yes, it's Kelson, CAL.
Yeah, CALSON. Thank you. And who resided there at that point?
It was me, our 3 kids, and Jack.
And how old are your children?
At that time, 15.
All right, and so what can you tell me about your experience with something that happened physical that you said going into midnight?
That time, we had a discussion on the 20th. And then I woke up in the middle of the night and.
Tell me more about what woke you up in the middle of the night.
Matt came out of I was sleeping on the couch. I've been sleeping on the couch. Matt came out of the bedroom, came into the living room, started touching me, trying to do things. I eventually got him to stop, and he said, "I feel like I'm raping you," and I said, "You kind of are." Stop and back to it.
Okay, so explain to me when you said on the couch, you said touching you. Tell me more about that.
So he came out and I was sleeping, he pulled me up, took the blanket off. Trying to feel me, took my pants off and my leggings I was wearing.
When you say feel me, tell me what his hands were doing to your body.
So just like feeling my.
Okay. And so when you say private areas, are you talking about, like your breast area, your vagina area, something else?
Vagina.
Okay. And I know this is hard, but could you explain to me what he was doing at that point?
Rubbing, trying to get me to get sleep. Wanting to sleep with him.
What were you saying, if anything?
I was just telling no, I don't want to, and then I started pulling my leggings off, and I tried to get them back up, and I not got to that point strong enough to keep that from happening. So then he eventually was inserted in me, and I just kept twisting my body around to get away from him, and eventually he stopped and said, "I feel like I'm breaking you," and it's kind of hard.
When you said inserted in me, tell me more.
His, yeah, I don't know, I guess I'll describe that.
Okay, so what did he do with his right penis?
He got on top of me and split it
Into your vagina? Okay. And were you getting emotional at this point?
I was more angry. I just kept saying no. And like twisting my body left and right to try to get him to stop, and then he eventually did. And it wasn't that hard of long.
Okay. Tell me more about trying to twist your body.
So I was on my back on the couch. He was on top of me, trying to sleep with me, and when he got his penis inserted inside me, I was using my upper half to like roll, or like get my legs roll around, so that I could like
What were you feeling at that point? What were you feeling at that point?
Anger, because the discussion we had the night before was moving out. I 110% don't want to be with him. Like we're just not going to be together. So I was very angry that this is now happening a second time, and I needed to get away from that.
And you said you were trying to pull your leggings up, but you couldn't. Tell me more about that.
So I was half asleep. Where I wasn't actually up. So I didn't register exactly what was happening on the text. I was half asleep, but so I was laying on the couch and he was on top of me pulling my leggings.
Okay. And what is your size differential at that point? Is he bigger, smaller than you, or something different?
I mean, bigger, stronger for sure.
Once you were able to twist your body, what happened after that?
He sat up and he said, I feel like I'm raping you. Kind of bar. And that's when it stopped and he went back to the bedroom. And then I woke up the next day, went to work. And I told him that I need to make sure that you follow through with your mom. That I want that to happen.
Okay. And you had previously said something about that was the second time or another time. Is that what you said?
Mm-hmm.
So,
Yes. Yes.
Could you tell me more what you meant when you said that?
So in March. Yeah, I don't know, but he came home drunk one night and I was out in the back room in the park with my son, my middle son, Matthew, who's 11. Matt had been texting me that he's coming home and realized he was home, but then when he got there, he came to the back room where we were and asked Matthew to go into the other room to talk to me. And my son hesitated, but I told him it's okay. So then Matt walked over to the couch that I was sitting on, so we have like two living rooms. and laid down on the couch, put his head in my lap, and was like sobbing, crying, and I was just like listening. I was kind of awkward, but then I grabbed the towel and put it under his head. It was just in tears and stuff. But then after about 10 minutes or so, I told him he could get up, go to bed. And then he sat up and sat on that end of the couch for a little while. And then I said, I'm gonna have Matthew come back in here. And he said, not yet. But then I called Matthew back. So then when Matthew came back to the back room, Matt got up and he went to the bedroom. Matthew and I played cards for a little while. And then Matthew said he didn't want to go to bed because he made sure that Dad was sleeping. So he went to make sure that Matt was sleeping in bed.
I have to stop you. The son named Matthew?
Yes.
You're gonna have to start the story over then, because you're gonna have to differentiate which Matthew you're talking about.
Thank you, Your Honor.
Thank you.
Sorry. So Matthew is junior and then Matt would be.
Okay, can we refer to junior as junior?
Sure.
Okay.
So you said that Junior went in to see if the defendant was sleeping. Is that fair?
Yeah, so she wanted me to repeat the story like every time.
Yes, because I got super confused when there was Matthew and Matt and Matthew.
I can do it.
Okay.
I'm sorry. Okay, so March, I think it's the 30th or so. Matt was at the bowling alley at Royal Scott drinking, came home, wanted to talk. And Matt Jr. and I were in the back room playing cards. Matt had asked Junior to leave so he could talk to me. And so Junior was hesitant, but I told him it would be okay. So he went into the other living room that we have. Matt got on the couch, laid on my, put his head on my lap, and sobbing, crying. I was, feeling awkward, but I was just listening, trying to be understanding. Grabbed the towel that was close and put it under his head so that my hands were getting wet. And then after about 10 minutes of this, I told him that he needed to get up and go to bed. Matt Jr. and I were playing cards, so we wanted to finish. So Matt sat up, sat at the edge of the couch for a few minutes, and then I called Junior back into the back room. Matt got up, went and laid down. Junior and I continued playing cards, and then Junior didn't want to go to bed until he knew that his dad was sleeping, so that I would be okay. So Junior went to make sure that he was sleeping, came back, but then Junior didn't want me to sleep alone, and I had been sleeping on the couch. There was another chair in the room, an oversized chair, so Junior slept there. And then around 4 a.m. or so, Matt woke up, came into the back room, and that is actually like the same kind of thing, started feeling, touching, took my leggings off. I was saying no, but then I remembered that Junior was sleeping in the same room. So then I wasn't trying to be like overly aggressive, but I didn't want him to wake up and like hear that. But I did say, no, stop, I don't want to do this. And Matt said, I know that, don't make me stop, I know what you wanted, those kind of things. But then with Junior sleeping in the room, I just stopped and allowed it to happen. And then Matt came inside me, got up, went, and I don't know what he did, but then after a few minutes of laying there, I was really confused, didn't know what to call, what just happened.
Tell me more about being confused.
Just the fact that, that happened, and I didn't want it to, but we were together for so long, so I'm like, I don't know what to, do I call this rape, or do I just call it like something for, we're not together now, or, and that's just,
So going back a bit, you said he was filling you up. What was he doing with your hands, and where was he placing them on your body?
My hands?
What was he doing with his hands?
Oh, it's just the same kind of like, touching up the vagina and like rubbing, trying to get me to move.
And at that point, you were saying no.
Yes,
And were you getting emotional at this point?
yes.
Tell me more about getting emotional.
So when I eventually just allowed it to continue and to let him finish so that Junior stayed asleep and it was just over, I was crying during that time.
Were you facing each other while you were crying?
Yep, I was just looking the other way. He was trying to kiss me and I wouldn't let him.
And so at that point, is defendant's penis going into your vagina?
Yes.
And that was not consensual?
No.
And tell me a little bit more about, you said you didn't know what to call it. Help me understand what you did after this happened.
So during from 4 a.m. to like when I had to go to work, I had to do it at 9 or at 9, sorry, not like 9. I didn't get much sleep after that. I, laid up and wondered and questioned what had happened. And then the next morning I texted my best friend and I said, I feel like I got raped at 4 a.m. She's like, what do you mean? So I called her and I said, what's going on? And she said, absolutely. And then I also, I refused at that point to like denial of some sort. I'm not really sure what it was, like mind wise, but I talked to my therapist, talked to my coworkers, and everybody's like, yeah, you didn't want it, and that's what happened.
And you're saying you were kind of confused because you had this long-term relationship. Is that fair?
Yeah.
Okay. And at some point in June, do you remember calling the Lansing police?
Yes.
Okay. Tell me what you remember about that.
So we moved out in April, and from April to June, there was a lot of back and forth, emotional. There's a lot of things, but so the calling of the police was because he came to my house, took pictures, called CPS, and made that whole thing. And they came and they left, and they're like, we don't see any issues. Nothing happened after that, but then after they came, he had also threatened 2 of my friends, saying that if I take my kids over there, then so CPS, it was for things that he thought was dirty in my house. And because he said that I take my kids to parties where people do cocaine and they are just like belligerent drunk and like unsuitable for kids.
Okay.
So that was part of that. And so he had also texted his friends that he was concerned about and told them that if I take my kids over there and he finds out, then he's gonna call the police and call CPS and send them to their house too. And so at that point, he had done it again to one of my really good friends. And I called the police to just have her come over and tell him to stop harassing my friends, leave me alone.
Okay, so you called basically because of the harassment, is that fair?
Yes.
Okay. And then a Lansing police officer did respond to your home?
Mm-hmm.
Is that yes?
Yes.
Okay. And at that point, did you disclose the sexual assaults to police?
Yes, so she had asked me questions about why I called, and then she asked me about the relationship I've had with him and the history, and then it just kind of led up to I told her that I was 17 years, a lot of domestic violence stuff. Then I said, he raped me a couple times, and that's when she red flag, asked me a bunch of questions, and I answered, honestly. But I didn't call her for that.
Yeah, but so when you said a lot of domestic violence stuff, what are you referring to?
We argued a lot. I'm not saying that the whole 17 years was every day arguing, but there was a lot of arguing, a lot of physical, mental. I called the cops a couple times. One time I called them, I don't think that's on the record anywhere because they ended up just leaving. In 2018, there was an incident where they've made, and that would be a record somewhere.
Okay, so you had prior experience with some kind of assaults in the past, is that fair?
Yes,
At the hands of defendant?
yes.
And so can you tell me, you said a little bit about going to therapy, but could you tell me what, if anything, you did after these 2 assaults to then cope?
That is a great question, and it's not anything like, the further I get away or more time that goes on, I realize how horrible it is. But like I said, when it happened, it was just wasn't surprising to me, you know, this is like, I tell stories of things and it's just, that's my life. I'm just, that's not, it's nothing unusual.
So did you seek more therapy after this happened?
Yes, I'm still.
And tell me about, did it affect your ability to sleep?
Not, I've never really been much of a sleeper.
And so, and you said you had work at 9 a.m. Is that a yes?
Yes.
Okay. Where do you work?
At the House of Representatives.
Okay. And how did it, if anything, affect your work or your everyday life?
I mean, I always went to work. I would confide in coworkers on situations, and they have seen me cry, and they've seen me, you know, they've given me words of advice and that sort of thing. There's days where I don't focus as well as I should, but I get through.
And did you go on any medication because of this? No. What, if anything, did it affect your ability to, you know, go outside and maintain a normal life?
Well, and it's definitely affected how I have a relationship with another man. Like, I'm always on guard, alert, every little thing. I'm judging it based on my previous past life. So it's hard to have a normal relationship.
Do you have flashbacks to the times he assaulted you?
Yeah.
Tell me more about that.
Just thinking about we'll be out doing something, and then I just, because it's Lansing, small town, there's things that will remind me of things that I've done with Matt, and it's just hard to be like, I've been here before, it's more deja vu, but it's not going to end up the same way as it did before.
And what was the most difficult part about that last sexual assault that you described when you were on the couch and your son was sleeping?
That was just understanding what happened and knowing that. And I've talked to my son, Junior, not in detail or anything, but like when the cops came and I finally had to, like, you know, I talked to the kids about things. He did feel bad. He said, I slept out there to make sure you're okay. And I was like, I'm okay. You worry about, but he's having a hard time with it too. So it was hard for me having him sleep in there, knowing that I can't have him wake up, so I have to just.
And after the defendant moved out, what were your sleeping arrangements like?
We have 4 bedrooms, and I was sleeping on the couch for a little while, and then I eventually had our daughter move into the bedroom that Matt and I had together, because I could not sleep in there. I will not sleep in there, and I took over her bedroom. Now I'm in the other bedroom.
Tell me about that bedroom. You just said you couldn't sleep in there. Tell me more about that.
I just can't, I barely can even, I don't even like being in that room, just because it reminds me of him and I together. And there's days where I just sat outside in my car because I hated being in the house.
And does that still happen even today?
Not so much as I have renovated it a little bit and it went up for sale and I sold it and, you know, I'm getting out of it, but it doesn't look the same like it did. When we were in that. But it's still the memories of being there.
I have nothing further.
Cross-examination.
Morning. I want to be respectful of you, so why don't you tell me, how would you like me to address you? Tabitha, Ms. Birmingham, how would you like me to, what would you like me to call you?
Yeah, it's fine.
Tabitha, I'm here to ask you some questions. The point of my questions is not to trick you or to confuse you. So if you don't understand one of my questions, I want you to tell me, I don't understand that question. I'll be happy to repeat it, all right?
Yeah.
I'll repeat it as many times as you need me to so that you understand it before you answer. Fair?
Fair.
The deal, the other side of that is that if you answer my question, I'm going to assume that means you understood it. Is that fair?
Fair.
You said that sometime in June, and I'll refer to him as, you refer to him as Matt?
Yeah.
All right, and again, I don't want to run afoul of the judge's issue with, in terms of, there are two Matts here, so I will call your son Matt Jr. and I will call him Matthew Jr. and I will call him Matt, okay?
Okay.
All right, so you said that sometime in June, Matt, the defendant, called CPS.
Yes, June. Yes.
And that phone call was made on June the 2nd. Is that right?
Yes.
Do you remember calling the police on June the 4th?
Yes.
So you would agree with me that Matthew called CPS 2 days before you called the police? You called the police and reported a late breaking and entering. You remember that?
Yes, I did report that.
You said that Matthew went into your house without permission,
Yes.
and that's, I'm sorry, and that's why you called the police. Why do you think you called the police? I'm sorry, let's be clear about something. You called 911.
I called the non-emergency line.
You did call the non-emergency line? Okay, so when you called the non-emergency line and you said, hey, I have an issue, what was the issue you reported?
The issue I reported was to have a police officer come out so I can talk to her, to have him, have the officer talk to Matt about stopping harassing my friends and myself.
Sorry, Your Honor.
Yeah, someone's phone's vibrating.
Yeah, I don't know.
I think it might be in this bag.
Mr. Abbott, is that Mr.
Yeah,
Abbott?
but I'm not sure. Sorry.
Oh, continue.
Thank you, Your Honor. So when you called the police on June the 4th, Matt, excuse me, I'm violating my own rule, I apologize. Matt, according to you, had been harassing you, right?
Yes.
He had raped you sometime in late March.
Anything. Yeah.
I was gonna get to that, but I'm only supposed to ask one question at a time, so they're not what's called a compound question. He had raped you in March, is that right?
Yes.
And he had raped you a second time in April.
Yes.
You called the police about a month and a half after the second rape, right?
Yes.
And you said, I want you to go talk to my husband and tell him to stop hassling harassing, or threatening my friends?
Talk to my ex-husband, but yes.
I apologize. You are correct. Talk to my ex-husband about threatening, harassing, and bothering my friends
And myself,
and yourself. You wanted the police to talk to him.
yes.
So the police arrived. You said it was a female officer.
Correct.
And she talked to you.
Yes.
Now you said that, would you agree with me that the first complaint you had once that officer arrived at your house was that Matthew entered your house without permission?
I don't remember the first sentence that, or, conversation that I've had with the police officer, but that was part of it.
Fair enough. Let me ask you the question this way. Did you report that Matthew entered your house without permission?
Yes.
Did you report that Matthew had been harassing you for some time?
Yes.
Would you agree with me that before you discussed the 2 sexual assaults or the 2 rapes, you discussed with the officer the 2 other issues?
Correct.
You discussed with the officer the home invasion or the breaking and entering?
Mhm.
Is that a yes?
Yes.
And you discussed with the officer the harassment?
Yeah.
Well, and you said during direct, I believe, that during the course of you talking to the police officer asked you about the nature of your relationship.
Yeah, correct.
And the police officer asked you, has he abused you? Has he assaulted you?
Yes.
In response to those questions, you first talked about some domestic violence that had occurred going back to 2018 and forward.
I mean, the 2018 is the one that you can find a record of, but the whole relationship, there's been back and forth.
Let me ask you a better question then. Thank you for asking me to clarify. You discussed with the officer that there had been a history of physical abuse or physical domestic violence, him hitting you.
And mental.
And mental abuse.
Correct.
So you discussed all of that before you discussed the sexual assaults.
Yes, because then she asked me to come back to, over to where her police car SUV was, so that she can discuss that further, away from my mom and dad and kids.
And so prior to you going over and away from your mom and dad and the kids, you had discussed with that officer the breaking and entering, right?
Correct.
The history of domestic violence.
Yes.
The history over the last month or 2 of harassment or threatening behavior.
Yes.
And at that point, the officer asked you about the nature of your relationship with Matthew. Is that right?
Yes.
And after all of that, and after the officer took you away from your parents and your children, you said something to the officer about the sexual assaults for the first time. Is that fair?
Yes.
And
well, she obviously knew about it to have me walk back to her car, but we didn't discuss details until then.
And it was in response to the officer asking you whether or not anything else had ever happened that you responded that Matt had basically raped you twice in the past.
Yes.
And that was the words you used, that he basically raped you twice in the past.
Yes, because in my mind, I still wasn't accepting that that's exactly what it was.
So let's go back. I don't want to confuse you like a Quentin Tarantino movie or anything. So I'm going to go back in time now. We're not talking about June anymore. You've known Matthew for quite a long time.
Correct.
You said you guys have been together for 17 years.
Yes.
You were 10 years together without being married.
Yes.
And when at least, I think 2 of your kids were born?
3.
All 3 were born. And then after being together for 10 years, you got married.
Yes.
And you were married for 7 years.
Yes.
And then you filed for divorce.
Correct.
And that divorce was finalized in January.
Yes.
Matt, continued living in the house after the divorce. He lived in the house until, I think you said, April 21st.
Yeah, that weekend.
Between the time of January of 2023 and April of 2023, for a period of time, the two of you, I guess, in relationship terms, were on again, off again. Fair to say?
Yes, but I mean, we were off and on again from 2006 or so.
All right, so the nature of your relationship is there were highs and lows, peaks and valleys.
Yeah.
And my question to you is that this on again, off again nature of your relationship existed kind of from the very beginning.
Yes.
And certainly that continued after the divorce was final.
I mean, it was a short window, so it wasn't really.
Would that short window have gone until the end of March?
Yes.
You guys would sort of act like a couple one day and then fight and not act like a couple the next day. Fair to say?
I mean, I don't think there was anything major that happened between January and March to be on and off again, but that's how it went prior.
You would agree with me that during the period of time from January until the end of March, the two of you were engaging in physical intimacy still.
Yes.
You were having sex with one another.
Yes. No. I'm sure.
What would it have been, say maybe once a week?
Probably not.
Once every couple of weeks? Did you, when was the last time, if we take away the rapes, all right, because obviously that's legally not sex, that's rape. We take away the two rapes. In your mind, when was the last time you engaged in sexual intercourse with Matt?
Probably early March.
Early March. Do you remember having sex with Matt on March the 30th?
I think that's the great thing.
Do you remember having sex with Matt on April 4th and 5th?
No.
And by sex, again, I'm talking about consensual sex. Do you remember having consensual sex with Matt on April 9th and 10th?
I'm gonna object to yes to answer. She said the last time she remembered having consensual sex was early March.
Did you want to respond to the objection?
Your Honor, I'm asking foundational questions for some cross-examination I'm about to engage in. I want to give the witness an opportunity to, to clarify, I mean.
Okay. I'm gonna overrule the objection.
Thank you, Your Honor.
So the last date I'm going to ask you about, I've asked you about March 30th, April 4th and 5th. Do you remember having consensual sex with Matt on April 9th and 10th?
No.
So I'm going to ask you about April the 5th. I'm going to ask you about April the 5th. Do you remember at us texting, you and Matt certainly continued to text one another about lots of things.
Mhm.
Is that, you would text each other about the kids.
Yes.
You would text each other about the divorce.
Yes.
You would text each other about random stuff like whether he could fix his car in your driveway or whether he could help you fix something in the house, right? Do you remember texting him on April the 5th?
No, I mean, I'm sure he did. I just don't know what it was.
All right. Do you remember telling Matthew the night before April the 5th, on April the 4th, or sometime early in April, that his penis was yours until he got a new girlfriend?
No.
Okay. I'm going to show you. This is from you, and the rest of it is from an investigation. She only gave you part of the text messages.
I just wanted to clarify, so I've seen, we have this.
You have the first page or two. Is what she supplied to the police. What she supplied to the police is inaccurate and incomplete. It had been manipulated.
Okay, so
Copy
there's-
for your honor. And a copy for you.
What is this?
I'm gonna establish a foundation right now, your honor.
Well, I'm gonna say this is a proposed exhibit.
Yes, Your Honor.
Was it already numbered?
I didn't see any stickers. I apologize.
You'll get it from the court.
Oh, okay.
Can I have a moment to look over this? I've never seen it. Your Honor.
Absolutely.
Thank you.
Take a brief few seconds. You can get it. She'll tag it for you. Yours. Or the one, I guess the one you gave her. Okay. This is one.
Go ahead, Mr. Harrison, please shoot.
We can do that after the fact.
All right.
Yep. He's on the record, so. You have to wait for Mr. Linton to come back. Mr. Ferguson, you ready on Moon?
Yes, Your Honor, I am.
On the record in the matter, the people of the state of Michigan versus Tina Moon, file number 20-02233FY, council appearance.
Jeff Brodowitz on behalf of the people, your honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Tina Moon, Your Honor.
How are you, Ms. Moon? Very well, how are you? I'm good, thank you. Today was the date that was set for a preliminary examination. My understanding is there's an offer from the people for you to plead guilty to an added count 4 of larceny, 200 to 1,000, and the people will dismiss counts 1, 2, and 3. Is that an accurate understanding of the plea offer?
Yes, it is, Your Honor.
Did you want to accept that, ma'am?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay, you can put your hand down. I have an advice of rights with a date of today on it. Is that your signature on there?
That's right.
Could you read this document?
Yes, ma'am.
You understand the rights listed here?
Yes, Your Honor.
Do you have any questions about these
No, Your
rights?
Honor.
Are you willing to give up each of these rights here today to accept the offer and plead guilty to the added count 4 of larceny?
Yes, Your Honor.
You understand that you're going to give up your right to trial, and you have a right to a jury trial, and at the time of jury trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses the prosecution intends to call. You have the right to call your own witnesses to trial, but present evidence. Can you mute him, please? or present evidence that you believe further a defense to the charge being brought against you. You understand those rights?
Yes, Your Honor.
You want to give up each of those rights today?
Yes. Yes, Your Honor.
Okay. Anybody threatening you to get you to waive your rights and enter a guilty plea?
No, Your Honor.
Any promises being made to you in exchange for a guilty plea?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that a guilty plea can result in a conviction that you may need to report to your employer, or you may need to put that you have a conviction on a future job application.
I understand, Your Honor.
You also understand that a guilty plea can result in a conviction that may have impact on your ability to travel to certain places, or could impact immigration status that you may be seeking or seek in the future.
I understand, Your Honor.
Okay. As to the added count 4 of larceny, 200 to 1,000, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
I believe I'm guilty.
Factual basis, please.
Yes, Your Honor, thank you, Miss Moon. I'm gonna turn your attention back to January 30th of 2020. Were you at 2023 Hamlin Street?
Yes, sir.
You're in the city of Lansing, Ingham County, state of Michigan. Is that
Yes,
correct?
yes, sir.
And you were there with a named David Platts, is that correct?
Yes.
And while you were there with Mr. Platts took some Cadillac converters from a Mr. Blunt, is that correct?
Yes.
And you were aware of what he was trying to doing, is that correct?
Essentially, yes. sir.
And you didn't do anything to stop him, is that correct? Your Honor, I have no additional questions for Ms. Moon.
Any questions from the prosecution?
Nothing from the people, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing November 3rd at 8:30 in the morning. When you leave here, you need to go down 1 floor to our probation department on the 5th floor so that they can get you checked in and you can get set up and scheduled for a pre-sentence interview, okay?
Thank you.
Do you have any questions for today?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the bench, Your Honor.
Thank you. You're all set for today, ma'am. Okay.
8:30 on the 4th?
Was it 3rd, I believe?
November
3rd.
3rd, okay.
Okay, on the record, in the matter of the people of the state of Michigan versus Jason Linton, file number 23-02146FY, council appearance.
Jeff Brado, it's on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Mr. Linton. We both appear by video.
Okay, and Mr. Abbott, I have a plea sheet that we need you to sign when you come back in from the other room. These people have offered for the defendant to plead guilty to an added count 2 of use of narcotic, cocaine, or ecstasy, and that the people will in exchange dismiss count 1. Is that your understanding of the offer that was given to your client, sir?
Yes, it is, Your Honor.
Okay, and Mr. Linton, can you unmute your device, please?
Yes, Your Honor.
Okay. Okay, do you understand the offer that I just stated on the record?
Yes, Your Honor.
Do you wish to accept that offer today?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Okay, Mr. Linton, you have the right in this matter to proceed to trial. You have the right to a jury trial. You have the right to require the prosecution to prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to the presumption of innocence. So you're innocent until the people prove your guilt beyond a reasonable doubt. You have the right to see, hear, or question any witness that the prosecution intends to call against you at a trial. You have the right to call your own witnesses to trial or present evidence that you believe further a defense to the charges being brought against you. Do you understand that?
Yes, Your Honor.
You also have the right to remain silent and not have silence be used against you. Are you willing to give up each of those rights today to accept the offer?
Yes, ma'am.
Anybody threatening you to get you to waive your rights and plead guilty to the added count 2 of use of narcotic?
No, ma'am.
Okay, promises being made to you in exchange for a guilty plea?
No.
Okay, are you currently on probation or on parole?
No.
You are under sentencing for Eaton County though?
Yes, ma'am. I'm in TRICAP right now.
Okay, and let's see. You understand that a guilty plea can result in a conviction that you may need to report to a future employer?
Pardon me, one more time, please.
A guilty plea could result in a conviction that you may need to report to your employer or put a conviction on a future job application. Do you understand that?
Yes, ma'am.
You also could have an impact on travel or immigration status that you may be seeking if you get this conviction. You understand that?
Yes, Your Honor.
Okay, and you still want to enter a guilty plea to the?
Yes.
Okay, as to the added count 2 of use of a narcotic, cocaine or ecstasy, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Mr. Abbott, factual basis.
Thank you, Your Honor. Mr. Linton, can you recall the day of April 7th of this year?
Yes.
And were you near the 400 block of Miller Road here in Lansing, Michigan?
Yes.
And that's in Ingham County?
Yes.
And you had some contact with the police that day?
Yes, sir.
And you had been using cocaine, right?
Yes.
And you knew it was cocaine
Yes.
because you've used it before?
Yes.
And you knew it was against the law?
Yes.
Thank you. Nothing further, Your Honor.
Any questions from you, Mr. Brodowitz?
Nothing from the people, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and willingly made. This matter will be set for sentencing November 3rd at 8:30. Do you have any questions at this time?
No, ma'am.
How long are you gonna be in TRICAT?
90 days.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Not from the defense. Thank you, Your Honor.
Thank you, you're all set.
Thank you.
You're welcome. Yeah, it's in the file. He needs to please, he's so Abbott can sign it.
I can take it.
Are we ready to go back on the record?
Yes, Your Honor.
Okay, we're back on the record in the matter of the people of the state of Michigan versus Matthew Birmingham. Counsel, you can continue.
Thank you. So Tabitha, I handed you a document that has been marked as Defense Exhibit A for identification purposes. I want you to turn to the first page of that document.
Okay, please.
Yes.
Okay.
That first 2 pages has the word Matt at the top of it.
Mhm.
So I would conclude from that that screenshot was taken from your phone. Matt, well, if you go to page 3, for example, it has T and tab at the top of it.
And I would object to laying foundation. I don't believe there's improper foundation to start talking about an exhibit that hasn't been admitted to the court.
That's why we're laying a foundation.
Are you trying to authenticate these documents? Is that what's going on?
I'm laying a foundation for their admission, Your Honor, yes.
Okay, I'll hold your objection while you continue this question.
Yeah.
Page 3 has a T tab at the top of it.
Yeah.
Those appear to be screenshots from your husband's cell phone, is that right?
Ex-husband.
Ex-husband, I apologize, that's the second time I did that, I apologize. From
Objection to
Matt's cell phone.
speculation to a cell phone that this isn't her cell phone.
It's not your
Which page?
cell,
We're on the 3rd page.
yes. Because.
You're asking her. If
I'll rephrase you.
those- Okay, thank you. Objection
you.
sustained.
You would agree with me that whoever's cell phone this is has the word tab and then T as the identifier for whoever they're texting with, right?
Correct.
All right, so back to the first page where it says Matt at the top of it. Those first 2 pages, are those in fact screenshots from your cell phone?
Yeah.
All right, did you send or give those messages to either the police or the prosecution?
Yes.
And these text messages, you would agree with me, discuss a conversation you were having with someone named Matt?
Correct.
Would that be your ex-husband, Matt?
Yes.
And if you turn to the third page where it says T or tab at the top of it, would you agree with me that those are also text messages between you and Matt?
Objection, speculation.
Well, she can answer if she agrees that these are conversations that happen between her and him.
Thank you, Your Honor.
So the objection's over.
Is that a text message exchange between you and your ex-husband, Matt?
Correct, but there's no date, so I don't know.
So if you turn to the fifth page of that document, there is a date and time above a continuation of that conversation. Do you see that?
I do see that.
Where it says Thursday, April 6th at 11:19 p.m.
Mhm.
Is that yes?
Yeah.
Underneath that April 6th at 11:19 p.m. is a conversation that appears to match the first two pages that were screenshots from your phone. Is that right?
Correct.
Okay. So if we go back to the third page, this is a conversation again between you and your ex-husband, Matt.
Correct.
Your Honor, I'm going to move for the admission of Defense Exhibit A.
Any objection?
Yes, Your Honor, I'm strongly objecting on a lot of grounds, but mainly hearsay. I mean, it's hearsay in terms of if he's saying it purports to be an out-of-court statement of his client, that it would be hearsay with no exception because he's not a party opponent. If he's saying that there's a hearsay exception for the victim, I would like to hear it, but I do not believe it to be an exception. I think this is pure hearsay. I also have problems with the authentication. In terms of, I think we've now talked about 4 of these. I think 11 pages. I mean, we're not asking if this is a fair and accurate representation. We're not laying the proper foundation. And so I would object on all of those grounds to the exhibit being omitted, especially for hearsay.
Do you want to respond?
Your Honor, it's not being admitted for the truth of the matter. The witness testified that she never said that your penis belongs to me until you get a girlfriend. This is direct impeachment because she in fact acknowledges in this text messages that she did say that. So it's not being offered for the truth of the matter asserted. The foundational objection is a non-starter. I mean, she admits this is the conversation she had between her and her ex-husband, Matt. If Your Honor I mean, I certainly can ask her to review as much of the document as she wants.
It's not being offered for the truth of the matter asserted, then it's not hearsay. So that objection is overruled. I have questions though. The first 2 pages are clearly not the same form as the remaining. However, I do see at least, I think this is page 5, where it looks like it's the same conversation that's noted on the first page. Am I reading that correctly?
Your Honor, so what happened is that the first 2 pages are screenshots that the complaining witness furnished to the police or the prosecution during their investigation.
So the prosecution provided the first 2 pages
to me in
as
discovery.
discovery, and now there's
I have
an authentication issue?
No, Your Honor, I didn't have an authentication issue with the first 2 pages. I had an authentication issue with all of the ones that I've never seen before today. And I also, because he did turn over, we have his cell phone extraction. So, I mean, we have better evidence than.
You have the entire phone conversation?
The entire phone extraction.
So he was only provided these 2 pages, but you all have the whole thing?
No, we gave him the entire phone extraction. We've just not given these. I don't know what these, I'm assuming came from his client's phone, just screenshotting.
So you have the entire conversation from the.
I do not have the phone extraction yet, Your Honor. The phone extraction is a massive document. It hasn't been provided to me. I'm not objecting to that prior to the preliminary exam, but I don't believe I've seen the phone extraction.
I can get the date we made it available if it wasn't already done.
Well,
Well, let's see if we'll provide, I mean, I fundamentally have an issue with you being provided some pages, and then when you've provided a complete document, and then there's a question about the authentication of it, but
Your Honor, just
but if you provided the entire document, and maybe we could just use theirs.
to finish my explanation, Your Honor, the after the first 2 pages, the rest of the document is me taking my client's cell phone, screenshotting the entire conversation instead of
a portion of it,
chosen bits and pieces of it.
I was gonna say, because the first page of this exhibit is the exact same thing from page 5.
That is correct, Your Honor.
Were you able to confirm if their full extraction was provided to them?
I can't find a proof of service, Your Honor, so I'm assuming they hadn't, did you come over to sign for that? Because I don't see that in here.
It was not told to me that it was ready for me to pick it up, so I haven't signed for anything.
But this is being provided for impeachment purpose then, correct?
Only being provided for impeachment purposes.
So it's really not an exception.
That's fine, Your Honor, if it's not being offered for substantive truth of the matter. I just would also clarify, I believe that all I've heard about impeachment thus far was that one sentence. So I just do think whatever some of this goes far outside the scope of that, but I understand it's not sensitive.
Right, I think he asked her about the question about his penis belonging to her until he gets a girlfriend. She said she didn't recall, so he was impeaching her on that. Is that accurate?
Yes, Your Honor.
Okay, objection is overruled. You can continue.
Tabitha, you can look as much of that document as you want, but I'm going to ask you about the 3rd page. Are you ready?
Yeah.
Okay. So, in this conversation with your ex-husband, Matt, did you in fact say you'll get a girlfriend quicker than I will get a boyfriend?
Yes.
And Matt, responded, not when you said it's yours till I get one. I feel if I can feel close to you a few times a year, it'll be okay. Is that what Matt responded back?
Objection here, sir.
Your Honor, again, it's not being offered for the truth of the matter. It's being offered to impeach her.
Objection is overruled.
Her response does not make sense without the proper context. He then said, if you were marrying me at 60 years old, I'll take it. Is that what Matt said, your ex-husband Matt said to you?
That's what it appears to be, yes.
Well, is there a reason? Do you doubt the veracity of the screenshot? Do you say that you didn't have this text message with Matt?
No.
In response to Matt saying what I just asked you about, you respond, I'm sorry I said that. I shouldn't have said it.
Correct.
So Tabitha, did you or did you not tell Matt that his penis was his until he got a new girlfriend?
Not in the way that you're thinking.
Okay, so why don't you tell the court which way we were
And
thinking?
you said that we had slept together at that time when I said that, or had to say that, and we did not.
All right, well, let's take away the fact, let's take that away from the question then. If whether you did or did not have sex with Matt that day, you said that you didn't say that your penis is mine until you get a new girlfriend in the way I'm thinking. Why don't you tell us the way you said it then?
Yeah, so now looking at this, I'm remembering it was a conversation to where he had said that if I wanted to sleep with anybody or anything that he'd want me to sleep with him if I wanted to, until I got with somebody else. So
And during the
then-
course of that conversation, you said to him, your penis is mine until you get a girlfriend?
No,
So what part of the conversation did that come into then?
there was no words, like it was where I wanted to end the conversation. And so I said, I didn't want to argue at all or anything. And so he said, I'll sleep with somebody, just let me know. I just said, okay. So then that's where I said, you know, I should not have even said that. I would be, but I shouldn't have said anything toward. And there's been many arguments and conversations and stuff throughout the years where I had just said what he wanted to say here to get away from the arguing and the conversation.
So are you saying that, so I'm clear, did you tell him his penis is yours until he gets a new girlfriend just to shut the conversation up or end it? Is that what you're trying to say? Because you said that before. You said things like that before just to end a conversation. Is that what you're saying happened this time, or are you just telling us what happened randomly?
This conversation is one of those times, but the whole "this penis is yours until I get a girlfriend" thing is not accurate. This wasn't a thing where I said, fine, if I want to sleep with somebody else, you know, let you know.
So he said, not when you said it's yours till I get one. And you respond, I'm sorry I said that. I shouldn't have said that. Why don't you tell the court exactly what you meant? What were you referring to during this text conversation with your ex-husband, Matt?
That conversation.
What were you referring to? I'm sorry I said that, when he said, not when you said it's yours till I get one.
I said, I'm sorry, I said that I shouldn't have said that, as in it to be where I said that if I wanted to sleep with somebody, then I'll let you know. He brought those words in, not me.
I'm confused. The text message says, or it suggests that you said that it's yours until you get one.
Because I said that I would sleep with him. He would be the person I sleep with if I need to sleep with somebody. He is the one that said it's yours.
Okay, so he's paraphrasing what you said, is what you're saying?
Yes.
So you said this about a week after your ex-husband Matt allegedly sexually assaulted you.
Yes, because it was very uncomfortable in the house. I did not want to have any conversations with sex with him. I just said what I needed to say to have him end the conversation and leave me alone.
Well, it didn't end the conversation. It went on and on, didn't it?
That night. This is text messages.
Okay. So you're saying that a week after your ex-husband Matt sexually assaulted you, you told him that you would sleep with him if you needed to sleep with anybody just to end the conversation?
Correct.
Do you remember texting with your ex-husband, or do you remember the weekend of Easter this year?
Yeah.
Right, I believe it was the weekend of April the 9th. You remember that?
Yes.
You celebrated Easter as a family, did you not?
Yes, I did not want to, but we did.
I didn't ask you if you wanted to or not. My question is, did you celebrate Easter as a family?
Yes.
And that included your 3 kids,
Correct.
yourself,
Yeah.
and your ex-husband Matt.
Yeah.
And at the end of Easter Sunday, you and Matt had consensual sexual intercourse, did you not?
No.
Do you remember having consensual sexual? Well, let me ask you this. Do you remember at the end of Easter that evening, spending the evening alone with Matt?
I mean, the kids were home. I was sleeping on the couch, so he was in the living room.
After the kids went to bed, was there a time where you and Matt were together, just the 2 of you?
I don't know, probably.
Were you guys watching TV or Netflix together on the couch?
Yes,
Were you cuddling together on the couch?
unwillingly. There's a few times where he made me sit next to him and be close to him.
So you're saying you cuddled with him, watched Netflix, but you did it unwillingly.
There was no.
At the end of that evening of cuddling and watching Netflix, the 2 of you had consensual sex, didn't you?
No. We tried, but there wasn't.
Karen, I would like to object and place something on the record.
Yes.
First of all, guys, are we publishing these to the court because we're admitting them as exhibits, or are you just using these for impeachment?
I'm using them for impeachment, but I think it's a lot easier for the court to follow the questioning as she did the last time if she has a copy of what I'm referring to in front of her, because the witness is going to have a copy of it in front of her. And I also, for the record, provided you a copy for courtesy purposes so that you can follow during the questioning.
For the record, Your Honor, on August 4th of 2023 at 3:33 p.m., we sent the defense discovery. That was after the substitution was filed. The substitution was filed on August 1st of 23. Within that discovery, the first page says we have additional information we cannot provide over electronic. Please come to our office to pick up. Prior to that, Your Honor, we did turn the entire extraction over to the public defender's office when they were the original. They had signed out for it and proof of service on picked up by them in August. But then after the substitution was filed, we then sent all the discovery August 4th at 3:33 with regards to having the extraction ready. It just wasn't picked up and signed for at our office, but it should be right there per the records. I just wanted to make the court aware that it was available.
Okay.
What the accusation was is that it was provided to me and that I had it, and I don't. In past practices, whenever large discovery like that is being made available to me, I get an email from the discovery coordinator person saying it's here, come and pick it up. I did not know that it was there. I'll certainly pick it up now. But whether that is true or not has nothing to do with me asking questions that go to impeachment of this witness's testimony on both direct and cross-examination.
Right. Well, she had objected to it being admitted as an exhibit. It's not an exhibit because he's just using it for impeachment, and he'll pick up the extraction. And I'm assuming this is more impeachment information?
Yes, Your Honor.
Okay, so then if it's not being admitted as exhibit, it does not need to be tagged.
Okay. I just thank you. Here's a copy for Your Honor, if Your Honor wants to follow along.
Okay, and then I understand that he didn't pick up the full extraction, but is it your position that you're still objecting to the authentication of this? Is that what your position is?
Your Honor, to be completely frank with the court, I was able to try to find on this page, like I was trying to match it. Yeah, but I've just seen these today, so I was trying to do that when we took that break, Your Honor, as best I could. It is, I have the extraction up. I mean, it's in a, I don't want to misrepresent. It's a 57,824 page document. So I was trying to match it up, but I could only verify one thing, and it was just that April 6th at 11:19.
Well, he's asked her on the record about the last set at least, and she was able to verify that it was a communication between the two of them. So I think that would satisfy that. And I guess to the extent she's able to do that on this, we can move forward.
Okay, thank you, Your Honor.
Thank you.
Tabitha. I'm laying a foundation that this is in fact a conversation between her and her ex-husband, Matt.
Okay, objection is overruled.
Thank you.
Tabitha, those are your dogs?
Yes.
Taking a look at this document, is this a text conversation between you and your ex-husband, Matt?
Yeah.
And you recognize this conversation and a lot of the things that are in it?
Yeah.
All right. I'm going to ask you to turn. There's little numbers at the top just to make it easier for us to follow. The last page, page 5.
Yeah.
On April the 10th, sometime that morning, did you in fact have a text conversation with Matt where he asked you, well, not okay with slapping emojis, but I want you to do what you feel you need anyway? And did you respond, just friendly, sad emoji? I still feel like we shouldn't be together.
Right.
He then said, okay, I'll try to understand. I very much enjoyed Netflixing with you, though, with 2 heart emojis. You responded,
Is that a yes?
Oh, yeah.
you responded, I enjoyed it too.
Correct.
Probably the most connection we have had in a while.
Correct.
And he responds, I felt the same.
Yeah.
And you said, if it confuses you or anything, though, we don't have to do that.
Yeah. But that was just sitting on the couch together, talking. We did not have sex that night.
Yeah, you made that clear, but you also said that you did it against your will, that you didn't want to sit and watch Netflix and cuddle with him. Right?
Right.
All right. The next day after it happened, you're texting him saying that you enjoyed it too, probably the most connection we've had in a while.
Because if I didn't say that I enjoyed it, we would argue.
Over text.
Yes. And I'm sure that if you read multiple other texts, you'll see that if I don't respond in the way that he wants me to, it's a fight and it's an argument. And that is how I've been programmed for 17 years to do that.
Tabitha, your testimony is still that this text message about Netflixing and having this the closest connection we've had in a while does not reflect that you and Matt had sex the night before.
Correct.
Tabitha, between Easter and April the 21st, which is when he moved out, you said the second sexual assault occurred. How many times did you tell Matt he could come over the house?
I told him, well, he still lived there.
Yes, but how many, that's a good point. Let me ask a better question. How many times did you tell him that you were okay with him being there?
Depended on the day.
Do you remember on April 14th, texting him and inviting him to come out to play cards with you and your friends?
Yes.
Do you remember on April the 17th, you telling him that even after he moves out, he can come over and visit the kids as much as he wants?
With me there, yes.
Did you say with you there?
Or if I knew, then he was telling me. I never did I say that he can come in the house.
Tammy, you have to wait for there to be a question before you can speak, okay?
Hand you another text conversation or what purports to be a text conversation. Your Honor. Tabitha, at the top of the document I just handed you, it says 747, again with the T and tab at the top of it, does it not?
Correct.
And this, if you take a look at this,
I'm sorry. Is she on the microphone? Okay, there's a microphone that's in front of you, so when you put that paper in it, it interferes with the feedback from the court recorder, okay?
here, let me get the ones we're not using anymore out of the way, so you don't have to juggle those. Your Honor, I think I may have given you the wrong one. I think I may have given her two, because this is the one we're talking about here. Tabitha, does this appear to be a conversation you had with your ex-husband, Matt?
Right.
I want you to take a look at as much of that conversation as you want, but this appears to be a conversation about Matt having your daughter Madison and the two of you talking about him bringing her home and dropping her off at your house. Is that right?
Right.
On the second page of that document, do you not tell him that he can go to the house and hang out with the kids even though you're not going to be home?
Right.
How many other times after Matt, after the divorce in January or after the two of you stopped being a couple in late March, did you tell Matt it would be okay for him to be in the house if you weren't there? Do you remember?
No.
More than 10?
I remember.
Or
And this.
I'm sorry, just a clarification. Did we get the date of the last one we were?
I don't have a date.
I'm sorry. The date of that is April 17th, 2023.
I have that as May 11th at 4:04:15 on 23.
Oh, May 11th?
So,
Okay, well, then it was May 11th.
I'm sorry, you said you have mail on?
well, I was just trying to,
Follow on, okay.
I didn't know what date we were representing them to be, but
Okay.
this is,
So this one with the 747 at the top would be May 11. Is that what you said?
that's what the same text is showing in the extraction, Your Honor.
I didn't ask the date because I wasn't sure of it, but it's certainly helpful to know that it was May 11th, because that would have been after when Mr. Birmingham had moved out of the house. So thank you for clarifying that for us. Tabitha, I've handed you another text exchange that it appears to be a text exchange between you and your ex-husband, Matt. Is that correct?
Correct.
A third of the way down the first page, it says Sunday, April 23rd at 2:39 a.m. Is that right?
Correct.
This would have been 2 or 3 days after Matt, your ex-husband, Matt, moved out of the house. Is that right?
Correct.
Give me the date again?
date appears on the, at least according to the Apple icon, Sunday, April 23rd at 2:39 a.m. This conversation again talks about Matt picking up or spending time with the kids. Is that right?
Not there, not one second.
All right, so I'm going to tell you to turn to the 1, 2, 3, 4, 5th page. Matt sends you a text that says, "Or with my tools out there, are you okay with me just swinging by to grab them whenever I need them, or should I always ask you first?" Your answer, yes, you can. Say hello to the boys, maybe not grab your cock with them in the room though, with a laughing face.
Yes.
He says, "What?" And then you point out to him that in texting you, he meant to say some other word. And he said, "Do you mind if I swing by the house and grab my cock, gun, and cock out of the garage?"
Yes.
He did not mean cock. And you laughed at that.
I did.
And you made a joke.
I did.
You told him not to grab his cock when he's in the garage.
Yeah.
This would have been 2 days after he had sexually assaulted you, according to you.
Yes.
The next page, after he asks you whether he should ask every time or whether he can just come over the house, he said, there's a text, "Oh my FG, oh my," we all know what that means. Talk to text is hilarious with 3 different laughing emojis. Is that right?
Yes.
And then you say, "You can stop by whenever."
Yes.
And he says, "Thank you."
For the garage and tools, yes.
I'm going to show you one more of these. Your Honor.
Thank you.
I want you to take a look at this text exchange. I'm sorry, I gave you the wrong one. It's part of the same exchange, but I had it saved separately in a different, and I apologize for that.
This one's the one you need back?
Oh, sure, Judge. I'm sorry, thank you.
Okay.
In this one, he is talking with you about dropping the kids off, and you again tell him it's okay for him to go into the house. This appears to be Friday, April 28th at 7:59 a.m. And you invite him for dinner.
What time did you say?
Halfway down on the first page, it says Friday,
Yeah.
April 28th at 7:59 a.m.
Yeah.
Above that, in the continuation of the night before, when you're talking about whether he can come over to the house when he needs to, your response is tacos if you are hungry. You made dinner.
Yes.
And you invited him to dinner.
Father, my kid, he's gonna go over to see the kids, and he's hungry, he's me.
Well, he was dropping the kids off, right? He had the kids, didn't he?
No, he was working.
Oh, he was working and he was
And
coming
he
over to see the
them,
kids.
Yeah.
Okay. He's the father of your kids, and if he's hungry, you want him to eat.
If he's there visiting the kids and he's hungry, I'm not gonna be like,
To be fair, this was a week after you say he sexually assaulted you.
correct.
Now let's go back to the date he came into your house. And you said that you didn't know he was coming over and you didn't give him permission to go in.
Correct.
Do you remember Matt texting you that he has Luke's phone?
This one?
Lucas's,
Oh, I know, I just,
your son.
right.
Did Matt text you on June 2nd telling you that he had your youngest son's phone?
I don't know.
Do you remember him telling you that he wanted to come by the house and drop the phone off to Luke?
No.
Or Luke? Do you remember him telling you that he found your son's phone in his truck and he was going to go by the house and drop it off to you?
I don't remember that.
You do remember that conversation?
I don't,
Do you remember that conversation being the same day he took the pictures?
no,
Do you remember that conversation being on the same day he called CPS?
no. There's no way that,
Well, there is a way. I'll show you in a sec. I just handed you another text exchange. Once again, it has T and tab at the top. And this appears to be a conversation between you and your ex-husband, Matt. Is that right?
right,
And you recognize that?
Yeah.
You see at the top there, it says Friday, June the 2nd at 3:05 p.m.
right,
And he said, found Lukey's phone in the back door of my truck. You said, sweet.
yes,
He says, stop and drop Luke's phone off to him. There's some other stuff, but what I'm focusing on is stop and drop off Luke's phone to him.
yes,
You didn't say don't come over. You didn't tell him not to go to the house. You didn't tell him not to drop Luke's phone off to your son, did you?
I did not tell him to go in the house and,
Did you tell him not to?
no,
Did you tell him not to go to your house and drop Luke's phone off? Lukey's phone out for him?
drop it off, he didn't need to go in the house.
So when he got there, you're aware that Lukey was home,
Yeah,
okay? And in the past, you would agree with me, you told him he could be in the house if the kids were there and you weren't. Just so we don't have to go through all the texts that we've sent you, you're denying that we've discussed text where you said he could be at the house with the kids when you weren't at the house?
not without my knowledge.
Well, he just told you he was dropping Lukey's phone off, so it was with your knowledge, wasn't it?
That doesn't say anything about going inside and hanging out, just drop it off.
But you had previously told him it was okay for him to go inside and hang out with the kids.
He wasn't coming over to hang out, and he wasn't there, he was there.
He was there to drop off Lukey's cell phone.
And leave.
Where do you say that in the text?
Where does he not?
Okay, well, I've showed you 5 texts where you said it was okay for him to be in the house when you weren't there, as long as the kids were there. Did you give him notice for some reason that on June the 2nd, he wasn't allowed to do that?
But if you notice in all the other text messages, he tells me what his intentions are and what he's gonna do, and then I agree. But here, nothing, here it says he's gonna hang out. Here it just says he's wrapping it off.
You would agree with me, he told you he was coming over to drop off Luke's phone.
Correct.
And you knew that the kids were there, at least Luke was there. Right?
Yes.
And while he's at the house, if you look later at that text exchange, he tells you he's upset about the condition of the house.
Objection, speculation. While he's at the house, I don't.
Well, fair enough.
Oh,
I'll
okay.
rephrase
I was
the
the
question.
speculation as to where his location was.
Yeah,
Okay.
sorry.
Fair enough.
Okay, objection sustained.
During this text exchange, does your ex-husband, Matt, bring to your attention his concerns about the condition of the house?
Yes.
And he took pictures.
Yes.
And those pictures showed the boy, one of the boys' bedrooms at least, was in really bad shape. Would you agree?
No. In his opinion, but not mine and not CPS's. So.
Okay, well, CPS came over on June the 4th, right? CPS came over 2 days after he called. Would you agree with me?
No.
Would you agree with me they didn't come over on the day he called, which was June the 2nd?
No.
So you're saying that if we go and get CPS's records, it's going to say they came on the same day he called, June the 2nd?
No.
Okay. Why don't you just tell us what day you believe CPS came to the house?
So Matt came into the house this day. Took
Ma'am, my
pictures.
question is, what day do you say CPS came to the house?
I guess, just for the record, I'm not
Nowhere
sure.
in this does it have the pictures. for me
Ma'am,
to look at
when
this.
the attorney raises up to speak, you stop.
Your Honor, I just would like to make a record. I just want to make sure we're doing it proper. I think if the witness needs her memory refreshed, maybe we should then approach, but having documents sitting in front of her while she's, I don't think it would be proper.
I would agree, because they're not even exhibits, so, and I'm not really sure what she's looking at. So if you could refresh her recollection or as she states, she doesn't remember. Versus, can we get these documents back from her that she has?
Sure.
That way she won't be tempted to look.
So I'm gonna ask you about the documents I just handed you. At the top of this one, it has the word Matt with like a mad emoji. Would you agree with that?
I'm objecting, I don't know. I thought he was using it to refresh her recollection. I think it would be proper for her to look through it and then ask if it did refresh her recollection and then continue if she said yes with questions.
Your Honor, I have to lay a foundation before I can ask.
Okay, are you refreshing her recollection or are you impeaching? That's for my information.
Well, we'll see, depending on how she asks the next
Okay.
couple of questions, Your Honor.
Okay, and so
Your Honor, I'm simply laying a
You want him-
foundation so that the record is clear as to what document we're looking at if somebody looks at
Right.
this 6 months from now.
well, I think what she's saying for proper performance, we don't need to do that yet because she's just refreshing her recollection right now. And then maybe you might need to do that if it now needs to be used for impeachment purpose.
Thank you, Your Honor.
Ma'am, go ahead and review as much of that document as you need to.
Yes,
You ready?
right.
Right. Is the first page text screenshot from your phone?
Objection. I don't believe that was the question that was asked. I believe that he asked, I'm just confused about the proper form of what we're doing right now.
I think he was trying to refresh her recollection And what was the specific question that you were refreshing her recollection of that she didn't recall? I don't think it was about this.
Well, what day
What day was
CPS
CPS came?
and
you. She
the
said she didn't
condition of
remember.
the condition of the bedroom at the time.
Okay, so does this exhibit refresh your recollection about that, since you didn't remember?
No, because there's no date on it.
Okay.
Let's talk about,
Can we retrieve it from the witness?
no, because I'm not done. She can turn it over and put it in front of her. I'm gonna ask her questions in a minute about this document.
Okay, you can turn the document over, and if he redirects you to that, then we'll use it again.
Thank you, Your Honor.
Thank you.
Tabitha, do a text exchange with Matt where he was discussing the condition of the boys' bedrooms,
One of the boys.
boys' bedroom. Which boy?
It's Lucas.
He sent you a series of pictures, did he not?
Correct.
And this was the same day he went to drop off Luke's cell phone. Lucas's cell phone.
Well, there's no date on this one.
Well, I understand there's no date on this. I'm asking you, from your memory, do you remember that conversation taking place the same day he dropped off Luke's cell phone?
No.
Do you remember it happening the same day he called CPS?
It did not.
You're saying that he did not send you these text messages the same day he dropped Luke's cell phone off?
I'm saying he didn't call CPS the same day.
All right, so let me ask you the question again. Did the text message between you and your ex-husband Matt occur the same day he said he was going to drop off your cell phone, Lukey's cell phone?
I don't remember if it was the day of or the day after.
You're aware that when he dropped Lukey's cell phone off, told you that he was upset about the condition of Lukey's bedroom?
I don't know if that was the same.
He did send you a series of text messages with photographs.
Correct.
And the photographs show Lukey's bedroom in a pretty bad state of affairs.
The bedroom wasn't used as a bedroom. It was just a storage kind of room.
There's dog poop on the floor, isn't there?
The upstairs, yes.
So it's okay to have dog poop in the upstairs?
Objection, relevance. I have no idea what we're talking about right now. It's for
What is the relevance?
Your
Yes,
Honor,
the answer.
the theory of the defense is that the complaining witness called the police a day or two after CPS was called to retaliate against Mr. Birmingham for having called CPS. The fact that he sent pictures to the complaining witness that showed that not only was the room a mess, but there was dog feces on the floor. When this witness has testified several times on direct that CPS came and everything was fine, is direct impeachment of her claiming that everything is fine. And it is part and parcel with the defense theory of the case. We're not bound by the prosecutor's facts or their theory of the case. The fact of the matter is the complaining witness called within a day or two after these photographs were sent to her and CPS was called on her.
So as it relates to credibility, I think it's allowed.
Oh, thank you, Your Honor. But just for the record, we haven't established a date of these. So if his whole relevance is based on a timeline, that's not been established. So just thank you, Your Honor.
Okay, we'll have them establish a date of this.
Well, and again, if I was offering this as an exhibit, I would agree that it would have to have a better timeline link. When it's being used for impeachment, whether or not it was on the same day or the day after, I would argue is completely inconsequential.
Whether or not the room or the condition of the room was.
I'll lay a more thorough foundation, Your Honor.
Yeah, because you brought up a picture, or you asked her about a picture where the room was in some disarray and there was some, I guess, dog feces on the floor, we need to know the date. And just to further the record, I think the date is helpful for Ms. Gallagher because she's trying to follow along in the extraction.
So Tabitha, what day do you believe your ex-husband Matt called CPS?
I don't know the date, but he came into the house, and if you see those text messages, it said, I did not give you permission to go into the house. He took
Ma'am,
those pictures.
as the judge has said, the rules are I ask questions, you answer them. Okay, I understand you have things to say, like you want to make it clear that in these text messages that are not admitted as an exhibit, you say he's not allowed to come into the house. My question to you was a simple one. What day do you believe Matt called CPS?
And I'm still objecting to narrative, and I believe the last question was not even fully answered. And if he wants a yes or no question, he should ask not an open-ended one.
I didn't ask you open-ended
Okay,
question.
wait.
I asked you
Well,
what day did.
I'm just trying to figure out the last question. What last question are you referencing?
I'm referencing the one prior that
The last question prior was, what date did Matt call CPS? That's not, you don't know.
Yeah, she did say she didn't know. I think she's answered that about 3 times.
So if you can't tell us the date, can you tell us in relation to when you received those pictures from Matt? What, was it the same day you received those pictures from Matt or a different day?
Nope, it was the day after.
So the day after you received those pictures from Matt, you believe Matt called CPS?
objection, speculation. I have no idea why this witness would know when someone called CPS. First of all, CPS, the identity of whoever calls is anonymous.
I'll rephrase the
from
question.
parties.
I'll rephrase the question.
Okay, but her last answer was yes. So why would you, how did she answer that? I'm confused. Are you answering, was that the date that CPS contacted you? Was the day after you got those pictures?
I don't know how I can answer this. I can explain, but it's.
Okay, well, okay, so as to speculation, then I will grant your objection. And, okay, and then anything that you want to explain, unless he asks the question, you can only answer his questions. You'll get an opportunity to be redirected later, okay?
Okay.
Tabitha, did Matt text you that he was going to call CPS?
Yes.
Did Matt text you when he says he did call CPS? I just called CPS. After he had called CPS, he said,
No, after they came.
After CPS came, Matt told you he had called them.
Yes.
Before they came, he told you he was going to call them,
If I didn't do what he wanted by a certain time,
which was clean up the house.
it was already.
So that all happened in a couple of day period. You would agree with me? 2-3 days?
No, it was,
1-2 days?
yeah.
And just so I'm clear, what, in relation to when Matt told you you had to clean the house up or he was gonna call CPS, what day was that in relation to the day he texted you he was gonna bring Lukey's cell phone home?
If the pictures were taken on that same day that he said he was gonna drop the phone off, where I told him I didn't give him permission to go into the house, the morning after is when he gave me a timeline.
So the morning after he arrived at the house, with Lukey's, or the morning after he dropped Lukey's cell phone off? Let me ask a better question. The morning after he texted you the pictures was when he said he was gonna call CPS.
Yes.
That was also the same day you called the police.
No.
What day did you call the police in relation to when CPS arrived at your house?
Within a couple days.
You would agree with me that CPS came to your house before you called the police?
Yes.
And you're saying it was within a couple of days of CPS coming to your house, you called the police?
Yes.
Let's talk about the first sexual assault allegation. You said that occurred in late March, maybe March 30th, right?
Mhm. Yes.
You said that you were in the living room with your son Matthew Jr.,
The back room. Yeah.
the back room with your son Matthew Jr.
Yeah.
And Matthew Jr. left the room.
He was asked to leave by Matt. Yes.
Matt asked him to leave the room,
Yes.
and so he left the room.
With hesitation, I told him it was okay. Yes.
Did Matthew Jr. leave the room?
Yes.
And you and Matt, your ex-husband, started talking,
Not really.
arguing.
No.
So what was going on in the room between the time Matthew Jr. left and Matthew Jr. came back?
Matt was drunk, came to the back room, asked Junior to leave. And then while I was sitting on the couch, Matt laid down on the couch and put his head on my lap and began crying and sobbing.
How long did that go on for until Matthew Jr. came back?
About 10 minutes, and then I called him back there because I knew that Matt would get up if he did.
So you called Matthew Jr. to come back after about 10 minutes.
Yeah, I didn't, he was it was very awkward.
So after about 10 minutes of this awkwardness, you called Matthew Jr. to come back.
Yes.
And he came back.
Yes.
You said that Matthew Jr. kind of fell asleep in an oversized chair.
He didn't come back there. Yes, he was.
My question is how long between the time Matthew Jr. came back into the back room did it take for him to fall asleep in the big chair?
So when I called Junior back into the back room.
Ma'am, how long went by between the time Matthew Jr. came back into the room and he fell asleep in the chair?
Couple hours.
What was going on for that couple of hours?
Him and I were playing cards.
You and Matthew Jr.?
Yes.
And what was Matt, your ex-husband, doing?
Sleeping in his room.
He came, and so it was just you and Matthew Jr. in the back room for that period of time?
Yes.
When Matt, your ex-husband, came back, was Matthew Jr. sleeping?
Yes.
And you said that your ex-husband, Matt, sexually assaulted you at that time?
Correct.
And you said on direct that you were gonna scream no, but Matthew Jr. was sleeping and you didn't want to wake him up.
I told Matt no a few times, and then when I realized that Junior was still sleeping and I didn't want to wake him up, I just gave up.
You didn't want to wake him up because you were being sexually assaulted?
Correct.
You understand that, of course, waking him up presumptively would have stopped the sexual assault.
Objection, speculation, badgering, that inappropriate.
Objection is sustained.
Thank you.
Do you believe Matthew Jr. waking up would have stopped the sexual assault?
No.
You think that Matt, your ex-husband, would have continued
Objection,
sexually?
speculation.
Objection sustained.
Thank you.
When when the sexual assault was going on, you said no a couple of times, right?
A few times, yeah.
Did you scream?
I didn't even scream, he was right there.
Did Matthew Jr. ever wake up during this?
No.
Did you attempt to wake Matthew Jr. up during this?
I wouldn't want to wake him up.
So the answer to my question is no?
No.
Sometime in late June, did you text your ex-husband Matt and tell him that you thought it'd be best for you and him to be civil to one another because of the kids, but that you were still hurt or upset about Matt calling CPS?
Objection, hearsay, relevant.
Hearsay. I'm asking her if she
She asked
texted.
about her
Yeah.
statement.
Yes, I'm asking her if she texted her ex-husband Matt and saying that following stuff.
Okay, the hearsay objections overruled, and you said the other one was relevance?
Yeah.
Yeah, repeat your question again.
Tabitha, sometime in late June, did you text your ex-husband Matt telling him that you thought it would be best for the two of you to be civil to one another for the kids' sake, but that you were still upset with him for having called CPS?
Oh, objections overruled.
Do I need to explain or?
Just answer the question.
Ma'am, you have to answer my questions. We have rules, and that's unfortunately the rules. So my question is, did you text your ex-husband Matt and say?
Yes, I did.
All right. By that point, you had told the police that he had broken into your home. This was late June, so it was after you had called the police.
Correct.
You didn't tell him you were upset about him going into the house.
Is that a question?
Yes, it is.
No.
You didn't tell him that you were upset at him for harassing or stalking you.
Not in that text message.
And you didn't tell him that you were upset at him for sexually assaulting you.
Not in that text message.
Did you ever text him about your belief that he sexually assaulted you?
No.
But you did tell him you were mad at him for him calling CPS.
Yes.
All right. I have no further questions, Your Honor. Thank you.
Redirect. Actually, let's take a 5-minute recess. It's been a while. And then we'll do redirect, okay? We're off the record. On the record. Is this all? I think that was the telephone. I was just trying to figure out what that noise was. Okay. On the record, in the matter of the people of the state of Michigan versus Vincent Flores, file number 22-03004. Appearance, please.
State councilman on behalf of the people.
Oh, we're not on the record. Kelly's not here. I have a question. He's not there. I did give everybody a. Okay, now we're on the record in the matter of the people of the state of Michigan versus Vincent Flores, file number 22-03004, council appearance.
State councilman on behalf of the people.
Thank you, and good morning or good afternoon, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Flores. He is in custody. He is not present in the courtroom today, I believe.
If you want to brought up, or are you going to waive his appearance for this?
I think I can waive his appearance for this matter.
Okay, today was the date set for preliminary examination. I think last week, we conducted the PCC remotely and discovery had not yet been received. How are we proceeding at this time?
So at this time, I am going to be requesting an adjournment from the court respectfully. The officer that we were planning to proceed with, under the MCL 768.27B rule, who took the direct statements from the victim in this matter. She does have a pre-planned vacation that she has to leave for at noon today. She also worked the night shift last night, so she's not slept in 24 plus hours. And she does have to leave for those pre-planned trips. She has been here since 9 a.m. this morning, around 9:15, I believe. So I do think that there's good cause for adjournment. I would note that Mr. Flores is in custody of many other matters. This is not his only matter. He's in custody until at least October 31st. So if we get that any date, we can run the preliminary at that time. I do believe that the defense does have discovery at this point.
Johnson.
Thank you, Your Honor. First of all, it is correct that I do have discovery now. Mr. Pfeiffer from the prosecutor's office helped facilitate that earlier this week. Honestly, obviously, I should say, Judge, I'm objecting to any adjournment. Today is the date and time scheduled for the preliminary examination. My client does remain in custody. This is not Ms. Castleman's fault. I apologize. That she said this. I had told her that I thought he was in. It's true that my client is in custody on other matters. I had said originally that I thought it was until Halloween. I was thinking of, I mistakenly said that in regards to a different client. He is in custody until at least October 6th. So we do have a couple, there's other matters that are holding him in. He has a sentencing scheduled with you, Judge. Nonetheless, today is the date and time for the preliminary examination. The defense is here and present, prepared to go forward. I would ask that the matter be dismissed for lack of probable cause.
So first, he's on bond. He has a bond in this of 35,000 cash short. So he's being held on this, which means when I took the bench at 8:22 today, called the first case. I asked about this case after 9 o'clock. My understanding is we were still waiting for the officer to get here. At no time, and then I was told, I think you came in as councilman and you advised that we were going to run the one that we're in now first, which if your client is in custody and he's not, yours should have went first. And especially you should have known that your witness has a conflict of timing so that we could have run that. So you managed that. I sat here and waited for you all to go with whatever one you were ready to go with first. You just made the decision to let this one go first, and now your witness is not available. That is prejudicial to the person sitting in custody. And so for that reason, I'm going to grant the motion to dismiss without prejudice. Obviously, they have the right to reissue the charge against your client.
Completely understood, Judge. Thank you.
Thank you. Okay, we're back on the record. Ready to redirect?
Yeah, thank you, Your Honor.
Thank you.
Thank you. Turning your attention to the March of 2023 sexual assault. Do you recall that? After that, who did you first reach out to and disclose what had happened to you?
On my way to work, I reached out to my best friend.
And that was the morning after?
Yes.
And what's her name?
The morning, it was same day.
Oh, okay, yes, it wasn't. So on your way to work.
Yes.
And what's her name?
Jade.
And then in April of 2023, after you were sexually assaulted, who's the first person you disclosed to?
I think my therapist or my coworkers.
And in between March and April, is it safe to say besides Jane, you might have told other people what had happened to you?
Yes.
Okay, but you were still processing it, is that fair?
Yes.
And so CPS were called for the first time, to your knowledge, ever in June of 2023? Okay. And what happened to that case after CPS came and talked to you?
Nothing. She came to the house, walked through it, went through everything, told me the allegations, and then as she was there, she was leaving. She said, "I don't see any issues. You know, follow up, but they could."
But she kind of reassured you before she left that everything would seem okay.
Correct.
And with regards to how this process has been, have you benefited in any way since the state of Michigan issued a warrant?
In what was?
Yeah, so was it hard to come here today, easy, or something else?
Oh, the worst. It's really hard to come here today.
And you had mentioned,
Anxiety-wise.
and you had shared something with me before we got out here today that sometimes when you're anxious or nervous, you sometimes laugh. Is that fair?
Yeah, I smile. I smile when I laugh, or when I'm nervous, or heated argument.
Tell me more about your anxiety to coming today.
I couldn't sleep well. I've had anxiety since learning I've had to come. Everything thinking about it. Couldn't sleep last night. Heart racing, feeling faint, just emotionally faint from it.
And you haven't benefited anything since this happened in terms of your situation with your children was already taken care of with the divorce in January 23?
Correct.
Okay. And so with regards to the original police call that you made regarding the unlawful entry, is that fair? Would you summarize it that way, or how would you summarize it when you first called the police in the beginning of June?
Like what I called for?
Yes.
I called to have an officer come out to explain to them to just have Matt and me and my friends alone and stop harassing us.
And you'd previously had a PPO against him, is that fair?
Yes.
And when the police were there, did you talk about a situation where the defendant came into your house without your knowledge?
Correct.
All right. And later, but before today's court date, did you send me, well, actually yesterday, did you send me an email kind of updating me about that situation?
Yes.
Okay. And what was it you learned and updated me about?
So over Labor Day weekend, my kids were with Matt, and when they returned on Monday.
Objection, Your Honor. Number one, this goes well beyond the scope of cross-examination. Redirect is specifically limited to, I didn't ask about anything that is even remotely related to an email that the alleged victim sent to the prosecutor last night. If over and above the fact that it goes beyond the scope of cross-examination, I would ask the court that as to what the relevance could possibly be.
Just want to respond.
Yeah, thank you, Your Honor. And that's fair in terms of the relevance is pretty apparent once you have the email, but without seeing it, and I did disclose it just right after I got it to defense, just for the record.
Okay.
But the email as an offer of proof had let me know that Lucas, her 9-year-old, had said that he let Dad in that day, and then later said, Dad made me remember that I let him in. And so I was just trying to, the whole thing with like this motive to lie, and that was this entire cross-examination. I was just trying to simply say that that was shared and that was additional and that was far after anything had happened.
Would not be hearsay?
Oh, yes, Your Honor, I thought he was objecting to relevance. I'm sorry.
Well, I mean, Your Honor, I would also state that the issue of it being beyond the scope of cross-examination, the reason that's a problem is because the email I received last night and the allegation that was made in that email that was not part of the direct, so I did not cross-examine about it, would lead to a 20-minute cross-examination because there are that many additional text messages where they discuss this. All right. I mean, I have cross-examination. I have text messages between the parties where the complaining witness
I have no
tells,
doubt that you have text messages between the parties.
that would directly relate to.
I get it. Yeah, we can move on. I was gonna say, I was gonna sustain the objection anyways, because I do. If I allow her to do that, then I gotta give you another opportunity to do this. And then let her redirect again. So we'll sustain the objection.
Thank you. You had said on cross-examination that, no, you never directly confronted the defendant about the sexual assault. Is that fair?
Correct.
Tell me more about that.
I still want to argue about it. And I was in denial of what it was. I wanted to keep the kids were happy. He was still at the house during that time, so I didn't want to think about it there.
And I just want to clarify because on cross-examination, I believe the quote was on again, off again was used a lot, but that means a lot of different things to a lot of people, including me. So I'm just trying to make sure that we have a clean record. So when was the last time you had consensual sexual relations with the defendant?
Beginning of March, maybe.
And so is it fair to say that after the sexual assault in March, you have and still have not had consensual sex with the defendant?
Correct.
And so it's safe to say that you had a ton of text messages with the defendant. Is that fair?
Yes.
Okay. And how was it talking to the officer about your sexual assault for the first time to the officer?
I was thrown off guard. I wasn't prepared to talk about it. I was very emotional and coughing.
Tell me more about being emotional.
Just saying that it happened out loud and calling it what it is hard for me.
By allowed, you mean to someone of authority, like a police officer?
Or anybody.
So when were you finally able to get the defendant out of the house permanently?
The weekend of April 21st.
And did that final sexual assault happen prior to that weekend?
Yes.
And so it's safe to say that after that first sexual assault, you were still living physically, I mean, with the defendant in some regards, right?
In all regards, yes, correct.
And just explain at that point what you were thinking about living there with him after that first sexual assault.
I voiced to him a few times that I wanted to move out, but he refused a few times because, you know, he said it's house, you can live here, you can stay here until I sell it. That kind of stuff.
How did it feel once he finally did leave the home?
Really.
How was it going through all those text messages on cross-examination?
It was hard because it's just text messages. There's no context for, you know, verbal or anything like that, you know, what was said before.
And you had a lot of communication, is that fair? I have nothing for the honor.
This one speaks to.
Yes, Your Honor.
Oh, let me double check to make sure. Give me just a moment. I'm going to see if I have a question first. Okay, actually, as to the home invasion, I do have a question. The date that you alleged there was a home invasion, that was on June 2nd, correct? Do you not remember?
I don't.
Okay, when did you first learn that he had been inside the house surrounding that incident? Was it on that day that he had been in the house?
I'd have to go back and.
You don't recall? Okay, so you do recall reporting home invasion to the police, correct?
Yes.
Did you report it on the day that it happened? No. Okay, and so did you know about it prior to the day you reported it?
Yes.
Okay, why did you not report it prior to that?
But I didn't want to cause any kind of issues or retaliation in that sense.
And after the incident where he had entered the home that led to the charge of home invasion, he was sending you pictures? Is that your recollection? Okay. Was it the picture that was shown in the text message of the room?
2 or 3 pictures.
Where were the pictures of?
One was a bedroom, one was one of my living rooms where I got, there was no furniture in there.
Oh.
And then.
Okay, and how did you think he got into the home at the time?
Just walked in.
Okay. And who was home to your recollection at the time?
Our 2 boys.
Okay. Any cross-examine or redirect based on those questions?
Diana.
in between the time you received the pictures Your Honor referenced and the time CPS showed up to your house, you cleaned that room. So CPS did not see it the way the picture reflected when it was texted to you.
Objection, Your Honor. Relevant.
What's the relevance?
Well, Your Honor, the prosecutor obviously asked her those questions because they're trying to make it sound like the CPS referral was unfounded. They asked about it on redirect, and then Your Honor asked about the photographs. I think it's important.
I asked about the photographs because the allegation, as it's pled in the complaint at least, is that he engaged in home invasion to stalk her. So I needed to know the basis of that.
Understood, Your Honor. Understanding the court's ruling, then I guess I have no further questions.
Okay, this witness may be excused.
Yes,
Thank
Your
you.
Honor.
There's a sequestration order. I think you are the only witness that was called or is going to be called, but the sequestration order means you are not to discuss any portions of your testimony with any other potential witness, okay? Okay, you're all set. You can call your next witness.
People have nothing further. Thank you, Your Honor.
Okay, is the defense planning to call witnesses?
No, Your Honor. Thank you.
Okay, you can proceed to argument.
Thank you, Your Honor. The people request to move over to bind over on counts 1 and 2 with the misdemeanor stalking to follow. And the people would move to amend the dates to March through April of 2023.
March. What specific date do we know?
I guess, Your Honor, just because given the CSC instruction with regards to date, I was just gonna leave it general, but I believe she said the 20th or 30th.
Yeah, the only reason I said this is just because she did state on the record that there was some consensual sex in March, but we'll do
Yeah,
March
you're right, Your Honor.
2023 through April 2023.
Thank you, Your Honor.
So you can continue. So you're not moving to bind over on count 3, correct?
No, Your Honor, with that new information, I was not moving to bind over, just because we haven't had the children forensically interviewed, and that's honestly why I was trying to bring up that piece, was to show to the kind of the court why I was not moving on count 3. But as to count 1 and 2, I believe there has been sufficient probable cause, and I believe that counts 1 and 2 should be bound over to the trier of fact in a circuit court jury trial. I believe all the elements have been met. With regards to force and coercion, I know Your Honor is well aware that it's sufficient force to just ignore the wishes of the other person. It's also sufficient force to pull on their clothes or assault in any kind of capacity. There was multiple kind of forced coercion that was testified to both in the March and in the April incident. And it was also testified to that the victim said no multiple times. She said that the one time she was crying and looking away while he continued to insert his penis in her vagina. And she said that at some point she just, I believe it was the first assault that she described, she said at some point after saying no multiple times and telling him no repeatedly, she realized she couldn't pull her pants up fast enough or overpower his strength. And that's how he then proceeded to sexually assault her. I believe this motive to lie in terms of the CBS allegations, as it refers to trial. I mean, I know that Your Honor is aware that a prior consistent statement after a motive to lie can come in as substantive evidence in circuit court trial, and that is why I asked about the first disclosures, because those disclosures would have been made prior to any kind of CPS reporting. And that is why I asked if CPS had been called more than once, or if it was just that one time. But I believe that this motive to lie with regards to CPS will be, should go before a trier of fact, and that the first disclosure witnesses will be able to more adequately put context around the situation. And because this is just probable cause, we ask for bind over. Thank you.
Defense counsel.
Your Honor, thank you. I have two parts to my argument. The first part is as to the elements of the certain offenses. And then a general argument against bind over in general. I guess a global argument about bind over in general. The specific arguments relate to the stalking charge. Your Honor, as a district court judge, I'm sure deals with stalking, misdemeanor stalking cases all the time. You're well aware of the law and the elements. I would simply suggest that the elements of stalking have not been made out on this record.
That's misdemeanor.
Yeah, I know, but they're asking to be bound over and continue.
Just goes with the companies. We don't need to address probable cause for that.
Your Honor, as it relates to the two charges of CSC first, I'm going to cite to People v. Petrella, 424 Michigan, 221, 1985 case, pages 270 to 271, as codified in Michigan Jury Instruction 20.9. Your Honor, Mr. Birmingham is charged with first-degree CSC, not third, on an issue of personal injury, on the theory of personal injury. Personal injury, certainly none of the actual physical bodily injuries would apply. So even though the prosecutor did not address this, I will assume they are binding over on a theory of mental anguish. Mental anguish means extreme pain, extreme distress, extreme suffering at the time, either at the time of the event or later as a result of it. Your Honor, there has been no evidence presented on this record that the complaining witness suffered either personal injury or mental anguish. And I would object to the bind over on the CSC 1, meaning over or above a CSC 3 on that basis. Your Honor, as it relates to the global argument about the bind over in general, I'm going to cite People v. Anderson, 501 Michigan 175, also a Michigan Supreme Court 2018 case. In Anderson, the Michigan Supreme Court sort of put to bed or put to rest this idea that preliminary exams are supposed to be just sort of some kind of like administrative rubber stamp of charges, and that Your Honor cannot look beyond the actual testimony, and that somehow, some way that Your Honor is required to accept the complaining witness's testimony at face value, not question it, or not make any kind of believability or credibility grounds. Reading from Anderson, I will state the following. At 184, magistrate is required to determine at the conclusion of the preliminary exam whether there is probable cause the defendant has committed a crime. Probable cause requires a quantum of evidence sufficient to cause a person of ordinary prudence and caution to consciously entertain a reasonable belief of the accused's guilt. Going on, this strongly suggests that a magistrate must consider the totality of the evidence presented at that juncture, and that a magistrate must do so even if the evidence introduced at the onset of the preliminary examination initially appears to have satisfied the elements of a criminal offense. Going on, at the bottom of page 184 and on to page 185, the court has held that during a preliminary examination, the magistrate has not only the right, but also the duty to pass judgment, not only on the weight and competency of the evidence, but also on the credibility of witnesses. Also on page 185, the prosecutor argues that a magistrate must accept the veracity of testimony offered at the preliminary exam. And the court countered by saying, we respectfully decline the prosecutor's invitation. On page 186, to the contrary, the adversarial nature of a preliminary examination would largely be meaningless if a magistrate were required to accept as true any and all testimony that is not patently incredible or that does not defy physical reality. On page 187, if a magistrate, I will skip over that. It is thus the magistrate's duty to determine whether there is probable cause to bind over the defendant. A necessary corollary of this general duty is the duty to pass judgment on the weight and competency of the evidence, but also the credibility of the witnesses. On page 188, in considering the credibility of the witnesses, a magistrate may only decline to bind over a defendant if the witness's lack of credibility, when considered together with the other evidence presented through the exam, would preclude a person of ordinary prudence and caution from consciously entertaining reasonable belief of the defendant's guilt. Your Honor, while the complaining witness in this case told a disturbing story, and one that is heard quite often in the context of abusive relationships and high conflict divorces, her credibility is seriously undermined by this idea that, the idea that she would be sexually assaulted in late March and then send the text messages that she admits to have been part of, and then she sexually assaulted again in mid to late April, and then again continue to claim that, as an example, her testimony within a week or two of the alleged first sexual assault, she's engaged in a text message where she acknowledges that the thing is mine until you have a girlfriend. Now, she denies that it was relating to the defendant's penis. But again, that is a basic credibility concern that Your Honor can determine on your own. We have the text from the morning after Easter, Easter being April the 9th, so the morning of April the 10th. That was the most connection I felt in a long time with you. I enjoyed Netflixing with you. Of course, she denied that they cuddled and watched Netflix together until confronted with the preliminary examination testimony. And then she said she was forced to do it. And then when confronted with the text messages that it was the most connection that she felt, she made something else up about why she would send a text message like that. Your Honor, text messages about joking around with the defendant about whether or not he should take his cock if he comes by the house in early May after both of these sexual assaults were to happen. Arguing about whether or not the defendant had permission to enter the house the day he took the pictures, when she had given him permission to go in there several times, and she even admits that at least two of her children, the two sons, were home at the time. Your Honor, I would submit to Your Honor that an individual who sort of comes before Your Honor without a history of this type of behavior out of the blue is just going to suddenly sexually assault his wife. That person's going to not do anything about it, including waking up her son because she doesn't want him to be disturbed in the middle of his sleep as the sexual assault is going on, and then be sexually assaulted again, wait almost 2 months before calling the police, and then admit that she only called the police after she received text messages about the condition of the house, is the kind of case, the kind of factual accusations that this court should have serious pause about. And under People v. Anderson, it's that kind of problems and flaws with the basic credibility of the complaining witness's story that this court should exercise its gatekeeping function and dismiss these charges against Mr. Birmingham. Again, understanding that I would rely on the first part of my argument as well in terms of the CSC1 becoming from a CSC3, because there's no evidence of personal injury or mental anguish. Thank you.
Just briefly, Your Honor, I believe that the texts were just trying to argue substantively, but it's my understanding that they should not be considered as substantive evidence. With regards to somebody having no priors, there was a documented 2018 dismissed domestic violence after the victim failure to appear. the people will be
Wait a minute, where was
noticing.
that brought into the record? There was no evidence of that. You don't get to argue evidence that isn't a part of the record of this case.
Well, by nature of her re-argument, she's saying the same thing against you because she said that the text messages, which was my ruling, was not evidence. They were used to impeach her.
And I said that
agreed.
they attacked her
And so
credibility, but what I'm
I
saying, there's no evidence that he was ever
I-
arrested or charged with
I-
domestic violence.
I agree, and that wasn't brought out during testimony, so we will discard that.
And just to make myself clear, it was only in response to him saying that there were no priors, there's no record. That was why
That's not what I
even
said.
brought it up.
I said with no history of engaging in this type of behavior.
Okay, I do believe her testimony was that there was some previous record of well, police and or court involvement. She did testify to that, so.
I think she said that there was a record of police being called.
Correct.
And with regards to mental anguish, Your Honor, that is the people's theory for injury. And I believe that we have taken testimony regarding not only during the event, after the event, the impact of her life. I think there was a lot of questions that were asked straight out of the mental anguish jury trial instruction. And a lot of them, I understand it's not a totality, it's not all inclusive, but I do believe that I asked them and fleshed out enough for a probable cause standard of mental anguish. Thank you.
Okay, so today was the date and time set for preliminary examination on one count of criminal sexual conduct, first degree. Count two, same criminal sexual conduct, first degree, and count three, which was charged as home invasion, third degree. Stalking is a misdemeanor, so we don't need to weigh probable cause at a preliminary examination. So, and count three being dismissed by motion of the prosecution. We're only addressing today counts 1 and 2 of CSC first under the theory of personal injury. And the purpose of the preliminary examination is to require the prosecution to meet their burden to establish that they have sufficient probable cause, as probable cause that a crime is committed, and probable cause sufficient to charge you with the crime. So this is a relatively low burden. It's more than mere suspicion is what the court is looking for. And the court, this is not a jury trial, so we don't need to weigh whether or not they can prove beyond a reasonable doubt. That's the standard for a jury trial in a criminal matter. So again, more than mere suspicion, and the court will be the sole determiner of credibility. And as argued by your attorney, the court also has the ability to weigh the likelihood of success at trial for the prosecution, as well as pass judgment on the weight and competency of the evidence that was presented today. Today, we had testimony from one witness, that being the alleged victim in this matter, Tabitha Birmingham, or the former wife of the defendant, Mr. Matthew Birmingham. She testified that the alleged incidents in question having occurred on or about a time period of March 2023 and April 2023 at the area of 6947 Carlson Drive, Lansing, Michigan, Ingham County, making venue before this court appropriate. She testified as to an incident in April where she stated she was sleeping on the couch and the defendant allegedly came into the living room, started touching her, took her leggings and took a blanket off her and leggings off. That he pulled her leggings off. She was trying to pull them back up. He was able to get them off. She stated that he made a statement to her during this interaction, that something to the effect of, "I feel like I'm raping you." She says in response, "You kind of are," that the defendant got on top of her and inserted himself into her vagina, that being penis to vaginal interaction. She testified that she was laying on her back and that during this interaction, she was attempting to twist herself in an effort to stop or hinder the interaction in some way, and that she had told him to stop. She states she was half asleep, that after the conclusion of the interaction, the defendant went back to the bedroom, that she woke up later, went to work, and later texted him or contacted him and asked him to move in with his mom so that she could prevent further actions of this kind in the future. She also testified about another incident having occurred on or about March 30th. She stated the defendant had been at the bowling alley, was drinking, and that he came in, he asked their child, what the mutual child, to leave, that he could speak to her, that he was sobbing, he laid his head on her lap, that she allowed this incident continued for about 10 minutes before she told the defendant to get up, and she called Matthew Jr., the mutual child, back into the room so that they could continue to play cards. She testified that Matthew Jr. Didn't want to go to bed until he knew that the defendant, his father, was sleeping. There was no objection to it. It's really hearsay. We can't speak to what Matthew Jr. wanted to do or what he was thinking. But that was her testimony. The victim states, or alleged victim states, that she was on the couch and that Matthew Jr. was on a chair in the same room. She states that around 4 o'clock in the morning, the defendant came into the room and that she attempted to engage in sexual intercourse, that she told the defendant no multiple times. However, because Matthew Jr. was in the room, she didn't want to wake him up. And so she carried on with the intercourse, penis to vaginal intercourse. The defendant eventually moving on the property in April. During the course of the alleged victim's testimony, there were multiple times in areas in which the defense counsel had to either refresh her recollection, or there was attempts for, and some very successful attempts at impeachment. So the court does have some concern about credibility, but I don't know that the credibility issues are enough to cause the court to disagree or to disbelieve the entirety of the testimony given today. So criminal sexual conduct in the first degree, to be proven at trial, the people would need to prove beyond a reasonable doubt that the defendant engaged in a sexual act that involved entry into the alleged victim, Tabitha Birmingham's genital opening with the defendant's penis. Any entry, no matter how slight, is enough, and it does not matter whether the sexual act was completed or whether semen was ejaculated. The people have charges under the theory of personal injury, use of force, or coercion. The defense counsel argues that there's not been enough information pled on the record, or evidence pled on the record, to satisfy, at least to a probable cause standard, the theory of personal injury, use of coercion. The victim was questioned during her direct, and I think a little bit even on redirect, about the effects that these alleged incidents had on her. She testified to having been in some counseling and having heart palpitations and anxiety, crying at work, being fearful, is what she alleged to have testified. Again, this is not a trial. This is just to a probable cause standard. I think to the extent that that supports a mental anguish or having to be in ongoing counseling and having anxiety would satisfy at least some of the questions that's even stated in the Michigan Model Criminal Jury Instruction 20.9, personal injury, use of force, or coercion. The other question or argument made by the defense counsel is whether or not Mrs. Birmingham was acting or making statements almost in retaliation of the CPS phone call. Mrs. Birmingham did give testimony at some point about, I think it was during cross-examination, but she was asked why she would respond or make certain statements in text messages, because the text messages, at least for the purposes of impeachment, raised some red flags for the court about the nature of the interaction and the messages that, or the message that, or intent that was being, or would have been portrayed to the defendant, and whether or not the defendant had reason to believe or that their interactions were consensual. The victim testified that she made certain statements because she felt either she had to, or to keep the peace, or to end the transaction because she somehow or another felt coerced. As to whether or not she's fabricating the matters at hand in retaliation, I questioned her myself about why she, or when she made a phone call to the police. It looks like she called the police on June 4th about to report an incident of stalking, which of course was dismissed, but the incident of stalking, she reported allegedly that he entered, or home invasion for the purposes of stalking, that he entered her property without her permission. There was some impeachment which shows some text messages where there was conversation about one of the son's phones being lost, conversations about the phone being found. She appeared to be excited about that, and there was indication in the text message that he was going to go and return the phone. There was no indication, in at least for the purposes of impeachment, that there was a concern about him entering the home or going into the home to return the phone. There was other impeachment testimony brought out that showed where there was various times between March 30th and or June, or through June 4th, where the defendant had been at the home or was invited to the home, was offered tacos, was engaging in regular family things, watching Netflix. There was a lot going on. But whether or not these incidences were reported in retaliation, I think is a question for a finder of fact, because we can't always determine why people report sexual assaults and why they don't. And so with that being stated, I'm going to find that there is sufficient probable cause to bind over as charged on counts 1 and 2 to go before a jury to determine the question of facts on that. Your bind over date, it's going to be September 27th. That is not a date that you need to appear in court. That's the date that the circuit court will get the file from the district court. And then they'll set your pretrial. Your attorney will be made aware of that. Okay, sir?
Yes, ma'am.
Your Honor, does my client need a waiver of the arraignment on the record?
No, our county no longer does that, so.
Thank you.
he's all set. So you'll get the notice of next court date. After that date, there'll be a pretrial. Bond will continue in this matter. Any additional matters for today's one?
No, thank you, Your Honor.
Not by the defense, Your Honor. Thank you.
You're all set.
Your Honor, may I approach?
Yeah.